The point of law that will be considered by your lordship, whether novation of a contract can be there by implication or requires a specific agreement between the parties. The Honorable Single Judge has referred to has proceeded on the pretext that in absence of an agreement, the revision of wages is not applicable to the petitioner. And BSNL 2008 is there. It can be either way, by agreement or by implication. And there are communications to establish that there has been proposal and acceptance. So the arguable point is there to place before my lords, my lord. If your lordship sees, they rejected my claim. Now, before I take your lordship to the merits involved here, matter once traveled to this honorable court and thereafter before the honorable apex court. The honorable apex court disposed of the SLP, saying that the petitioner must first take recourse of the dispute resolution forum clause 12, then approach the appropriate authority or court. Lord, we resorted to clause 12, applied them, they rejected it, annexure 21, page 130. They rejected it, madam.
There was no arbitration clause here.
No, but I verified that. That arbitration clause, if lordship sees clause 12, it's there in this way, it is here. But that is at page 58. Running page 58, clause 12, settlement of dispute clause 12. They have their own machineries provided for resolution of the dispute.
Not for under the arbitration act.
That's right.
But then ideally a suit should have been filed.
In fact, in view of the admitted position, they themselves have applied for revised clause for the petitioner by writing a letter to me. I think the Honorable Single Judge has failed to appreciate that part of the case. If your lordship sees one just letter, the wage revision went, they proposed by Coal India Limited, if your lordship sees, annexure 9. They themselves have issued a letter to me, page 74, that you exercise your option if you will be availing this wage revision in terms of the circular resolution passed by the Coal India. But they themselves have written this letter to me. There is no dispute about that. When I represented them, they did not act upon it. And I have to approach your lordship. And your lordship sees there are two stages which in the agreement itself, which makes applicable to the revised wage. That's there. There cannot be any disputed questions of fact. If your lordship sees page 57. Page 57, kindly similar. Roman 11. Third line, the contractor and contractor shall not pay less than the minimum wages to all workmen engaged for the work as per the Minimum Wages Act or such other legislation or award, or the minimum wages fixed by the central government as may be in force, means a prospective application.
Or you say notice returnable. 2nd August.
2nd August. Great point.
Item number 2.
Meet your lordship. But annexure 11 is the subject matter of dispute for lordship. If lordship, initially the court actually granted the relief in my favor, that is annexure 3, and subsequently a review application has been filed at page 75. But the order is with due respect, Lord, is absolutely cryptic and without assigning any reason. They actually taken note of the fact that Ajib have been penalized and punished for the purpose of indiscipline at a relevant time. But in fact, if your lordship looks at annexure 4, kindly have a look at annexure 4, Lord. At page 48, the resolution that has been passed after the remand was made by the High Court with regard to the inquiry, they have specifically stated the reinstated in service was holding earlier as lecturer in political science. He is the senior most lecturer. And the other service benefits of Mr. as the seniority increment is allowed to him on the date of initial joining on 14/9/91. The salary of Mr. is to be fixed notionally. The appointment of Mr. is to be treated as regular from the date of his initial joining. But therefore, he has been given the benefit from the date he joined itself. And there is no such adverse entry. The only 3 increments has been stopped. But the court has taken note as if I have been penalized, therefore my seniority cannot be taken into account for the purpose of appointing the principal. that was granted in my favor. Let's say, remember 2020, there was a circular. In the circular, government wanted to introduce the fact that from the date of birth, the seniority has to be counted. That has been caused by Drs. Panigrahi. It was confirmed in writ appeal before your lordship. Therefore, that cannot be.
Somebody's entered caveat.
Yes, somebody has appeared in caveat.
My lord, I have, but my lord, copy not served to me.
You can serve it. You see, caveat petition, you say, since he has appeared, this caveat petition stands disposed of. The main writ appeal, you say, notice, he accepts notice for opposite party number 6. And that Mr. Kunti accepts notice for respondent numbers 1 to 5. No, 1 to
1 to 5.
4. 1 to 5, is it?
Well,
1 to 5. Right. All right. Who is now in charge?
But
opposite by note 6, man.
so
You are there.
OP number 6 is
Note
a.
6.
All right. So we'll just set down for final hearing then. No, we'll only have to hear it finally.
I mean,
Final hearing on 1st July.
Was not
25th July. 25th July.
All right.
All right.
Item number 3.
copy may be served.
That will come.
May I please, Lordship? This is the second writ application filed by the petitioner, my lord. In the earlier writ application, your Lordship, my lord, was pleased to dispose of the writ application because in the earlier repentation, there is no proof of filing of that repentation. And your Lordship, with an observation, disposed of that earlier writ application, that it would be open to the petitioner to file fresh repentation. And accordingly, the petitioner filed fresh repentation by Annexure 2, page 11, your Lordship. And the authority, my lord, page 14, it is my lord, I mentioned that there is no specific direction from the Honorable Court for compliance, your Lordship. That is why the latter repentation was pending before the opposite party number 3, my lord. Annexure 2, your Lordship.
There's no specific direction from the Honorable High Court for any compliance, meaning what?
Because, my lord, page 10, your Lordship. Earlier, your Lordship, my lord, was pleased to dispose of that the repentation filed in the earlier writ petition was not bear any proof, my lord. That is no postal receipt or any acknowledgement.
Or you see, the petitioner's representation bracket Annexure 2 will be examined by the General Manager, Telecom District.
I am appearing for 2 and 3.
And after giving the petitioner a hearing, a reasoned order shall be passed. After notice to the petitioner and opposite party number 4 and giving them a hearing, a reasoned order shall be passed not later than 15 June 2023 and be communicated to the parties within a week thereafter. The court clarifies it has not expressed anything in the matter. A copy of this order be sent forthwith by the registry to the opposite party number 3 for compliance.
Deeply
know.
You
obliged.
can also counsel will also communicate this order.
The allegation is that the opposite number 4 is encroaching upon the government land adjacent to the boundary wall of the telephone department. The allegation is that the opposite party number 4 is encroaching the government land. That is the allegation. Paragraph 3.
So what will the General Manager Telecom do then?
Yes, my lord.
My lord, the telecom colony, near the telecom colony, my lord.
No, near is one thing, within the telecom colony is another. If it is near, then
It
the
is
telecom...
adjacent, your lordship.
Then how can this
They
General Manager
make
can't do anything?
cattle shed and it is not possible to, my lord, reside
No,
in
whose
the
land is
colony.
it?
My lord,
Whose land is it?
Government land.
No, government mean which government?
Revenue department, he says also, in the repentation also, he has said the revenue department.
Then what's the point in making representation to General Manager Telecom?
because my lord, that is the, my lord, telecom colony situated, my lord, there.
No. This land, according to you, in your government, vacate encroachment made over government land near telecom colony.
Yes, your lordship.
Not within the telecom.
Not within, my lord, it is adjacent to them.
If it is adjacent, then that is government land.
Yes, your lordship.
Then you have to again make representation to the government, not to the general manager telecom. Counsel to the petitioner points out that the encroachment, you see, counsel appearing for opposite parties 2 and 3 points out that according to the petitioner, the encroachment is on government land, which is near the telecom colony. Stop. Accordingly, the representation should have been made to the state government and not to opposite party number 3. Full stop. Paragraph. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to first approach the state government and after following up on such representation, appropriate remedies in accordance with law. The petition is disposed of as withdrawn with liberty.
Obliged, deeply obliged, your lordship.
Item number 4.
My lord, I'm in virtual mode, my lord. I'm in
Yes.
My lord, your lordship has directed the government to take instruction.
Yes,
The fact
my
is that in spite of the order passed by the Supreme Court in the PIL number 24248 by 2012, the
HL Bridge on 12th kilometer. Okay,
Yes.
he's giving some instruction. Let's see.
My lord, I have received the instruction. What my learned senior is saying, I don't know. But my instruction is that this bridge is already open for traffic since 2014.
Oh, I see.
5th January 2014. All payments have been made and work is completed within the due time. Contractor has been paid with the entire dues and the bridge is open to traffic since 5th February 2014.
no, that's not correct, madam.
That is my instruction.
But let them file an affidavit, my lord, in that aspect.
This is a government letter. Your lordship can note it.
No. Well, that is not utilized. That several paper publications as well as I have given the representation. They have not replied also my representation.
No, but the bridge is completed some 9 years ago, sir.
9 years, bridge but approach road has not been connected with it. For which it is not utilized. It is not utilized.
Approach road. That is not the case of the
No,
petitioner.
but the bridge is open to traffic.
No, that is not correct, my lord. It is totally incorrect. Let an inquiry be made by the order of the Supreme Court, or let them file first to be affidavit in that aspect, the concerned engineer. That's why I had given the letter also, they have not replied me.
No, after the earlier order of this court was 20th November 2012.
Well, my lord, the advocate who conducted the case by that time, he has become a judicial officer now. After a long time, now that read it itself, because there are paper publications, I have also annexed 3.
No. Where after the earlier order, when did you make a representation?
That I have not I simply first I made the representation by the Annex 4 in the year because I was not concerned earlier. 25/11/2022. I made the representation, and they did not reply to that.
After 2014, they made the representation in 2022.
After 10 years.
No, that I was not the earlier petitioner. The petitioner who was earlier he had filed the case, he has become judicial officer, he is nobody there. And now the villagers approach me, and that's why I filed this case.
No. Let's try and understand, sir.
Yes.
2012, the court passed an order
Yes, my lord.
saying complete the bridge within 6 months.
6 months.
What did the petitioner do immediately after that?
Petitioner who was a public spirited person, but he was come to the picture in the year 2022, my lord.
How can it be, sir? You can't wait for 10 years.
No. That is not. It is a fact that not be the
And both the paper cuttings they have annexed. That is
Yes,
also of the year 2012.
Oh,
There is no risk.
it seems some signed paper was left and they simply
No,
used
my
that
lord.
signed paper.
Also,
It is open for traffic. Your lordship
Yeah.
can record the instruction.
You see, it appears that the earlier order was passed by this court in writ petition civil. bracket BI number 24248 of 2012 on 20th December 2012, whereby the bridge in question was asked to be completed within 6 months thereafter. Paragraph. The petition is silent on what the petitioner was doing for nearly 10 years thereafter, when he made a representation on 25th November 2022, claiming that the bridge was still not, the construction of the bridge was still not complete. Paragraph. It now transpires from the instructions, written instructions dated 11th April 2023, given to the learned additional government advocate by the Executive Engineer, Rural Works Division, Jajpur, that the bridge in question, that the construction work of the bridge in question was completed way back on 5th February 2014. And the bridge has been open to traffic since then. Paragraph. In that view of the matter, the court is not inclined to issue any of the directions prayed for. The petition is disposed of.
Item number 5.
Cabin Puri District Judge. Puri District Court DC cabin. I am appearing for the petitioner, my lord.
Yes.
My lord, this is a PIL case for construction of railway overbridge. So, my lord, as per Annex 3, Railway Board sanctioned money in the year 2017. But state government is not providing land for construction of railway overbridge, for which it is delayed about 5 years. My lord, I have filed a representation petition before the collector Puri. He forwarded the same to Tahsildar Satyavadi. Still, my representation petition is pending before the Tahsildar. My lord, kindly direction may be given for disposal and provide land for construction of railway overbridge.
But so far as construction of railway overbridge is concerned, the railway department has to send a requisition to the Tahsildar or the collector for acquisition of the land to provide necessary
So that
land.
East Coast Railway has written a letter, Annex 3. Just see that.
Yes. So on the basis of this requisition, the work is to be progressed.
No. So he has sent it to whom? This deputy engineer?
Lordship may direct the Tahsildar to take necessary follow-up action on the
It appears
requisition.
that upon the representation earlier made by the petitioners for construction of a Sakhi Gopal railway overbridge made to the collector Puri, which was forwarded to the Tahsildar. A letter was written to the petitioners on 19th May 2021 by the Deputy Chief Engineer in the office of the Chief Administrator, East Coast Railway, bracket Annex 3, stating that after land for construction of the diversion road is handed over by the Odisha state government, the construction of the ROB will be taken up. Paragraph. The direction is accordingly issued to the collector Puri to act on the aforementioned letter dated 19 May 2021 of the ECR and take the necessary steps for facilitating the construction of the ROB. Full stop. The collector Puri will communicate to the petitioners the outcome of the deliberations with the ECR on the issue and time frame within which the work will be completed. A copy of this order be communicated both to the General Manager ECR as well as the collector Puri. Both with. The petition is disposed of.
Obliged, my lord.
Item number 6.
May it please, Your Lordship. Your Lordship, there's a second round of litigation pertaining to the location of the headquarters of the Western Odisha Development Council, Your Lordship. On the last occasion, in another writ petition, this Honorable Court had directed the Chief Secretary to dispose of my representation. They have disposed it off at page 24, Your Lordship, stating that the members of the council, including the elected public representative, that are 10 MLAs and 2 MPs, could not reach a decision in the matter and has requested the government to maintain status quo for another 3 years, Your Lordship. The Act clearly says that the headquarters need to be in the council area, Your Lordship. The Act is of 2000. We are in 2023. The headquarters are still in Bhubaneswar.
Which is the act?
The Western Odisha Development Council Act, Your Lordship. I have annexed the Act at page 12, Your Lordship.
Counsel for the petitioner points out that
No, my lord, your lordship may kindly see para 4 of the page 24. What he is saying that is not correct. Views of chairman was invited for passing a reasoned order as per direction of the Honorable High Court Orissa on the above issue. He has submitted that the 50th meeting of the WADC held on 27/12/2021 deliberated on the subject of the location of the headquarters of the OWC in any place in the 11 district covered so and so as intimated earlier to the government. The members of the council, which included 11 so and so 10 MLAs, 2 honorable MPs, examined the various options but could not reach a decision in the matter as a specific location. The council meeting resolved that the government may be requested to continue the status quo for a period of 3 years. 3 years from the date of that meeting, that is 27/12/2021. So they requested that till the end of 2024, status quo may be issued. So unless there is a consensus amongst the members of the...
No, let's see the act. Just see the act.
Yes, Your Lordship. Page 13, Your Lordship. Clause 3, subclause 4. The headquarters of the council shall be at such place within the council area as may be notified in the Gazette by the government in consultation with the council, which shall meet for a purpose at such place as the government may
In
fix.
consultation with the council.
That doesn't mean that it will not be set up.
Yes,
No. It is mandatory on the part of the government to consult the council.
That's all. It's consulted. But
Yeah.
it has to be, now after consulting, it has to now notify the place.
No, place is notified.
No,
He
no.
wants that it is to be shifted to any area
No,
within the...
it has to be
notified within the place
within the council area.
Yes,
Within the council area, but now the council members have...
You can't defeat the purpose of the act then. Suppose, let's say the members again after 3 years say we're not agreeable. So this will go on endlessly.
Because the word consultation in government is to
No,
consult
but
with
before
the-
that, shall be at such place within the council area. So they can have a consultation on where within
Your
the
lordship
council
may
area.
imagine, because they are all elected members. They have unanimously resolved that we will stay here for the sake of convenience in Bhubaneswar for 3 years. Thereafter, we will shift. So this is why the chief secretary has ordered that we have to give respect to the unanimous decision of the members of the
council. What do you say?
the purpose of the act will be defeated, Your Lordship, for the convenience of the MPs or MLAs or the elected representatives.
Those very people are saying we
Yes, sir.
find
Yeah,
the action to be in Bhubaneswar.
The act itself says it
The
shall be
members-
at a place within the council.
The members are
Right.
MLAs of that area.
But this
The members are saying, no, it is more convenient for us to have it.
But
have it in
they
Bhubaneswar.
cannot go against the act, Your Lordship. It's contrary to the act.
No, the only consensus they are able to arrive at is that continue in Bhubaneswar for 3 more years.
The purpose of the act will be defeated.
No, then
since
you have to
2000,
respect both parts of that section.
Your Lordship, since 2000, the headquarters must be in the council area, but since 2000, it's
No,
still
no.
Bhubaneswar.
As may be notified in consultation.
Yes, Your Lordship. The act,
that part we can't ignore.
they need to consult and agree on a place which is within the council
They
area.
refuse
Not
to agree. They
They did
only
not
agree
agree.
to Bhubaneswar. They're not agreeing for any other place.
Your Lordship, with all due respect, they need to agree with that.
No.
For the act itself says it shall be at such a place within the council area.
This is not a matter for PIL, because with respect to my respectful submission is that they are to hold the meetings of that council they say that it is convenient for us to, so they requested to maintain status quo for 3 years from the date of that 58th meeting. Thereafter, there can be, so without
So continue
consulting,
forever, Your Lordship. After 3 years also this will
how can
happen.
you anticipate that?
No,
How can you anticipate that?
prior to this also in 2017 or something, they had stated that by next year we will be shifting to the Western Odisha area. They have not. This will go on forever, Your Lordship.
You see, the question as to where the headquarters of the Western Orissa Development Council bracket WODC bracket must be located is the subject matter of the present petition. Stop. Earlier, the petitioner had approached this court with writ petition civil 4263 of 2021, which was disposed of by an order dated 13th December 2022, requiring the Chief Secretary Odisha to treat the said writ petition as a representation. And after giving the petitioner hearing, to pass a reasoned order. Paragraph. The Chief Secretary has complied with the above direction and passed reasoned order on 23rd February 2023. Paragraph. Article 23. After consultation with the WODC, which was WDC, which included the then members of the Legislative Assembly bracket MLAs and 2 members of Parliament bracket MPs of the Western Orissa districts. Full stop. It appears from the order issued by the Chief Secretary, which has been challenged the present petition, that the members of the WODC open petition could not reach a decision in the matter of a specific location in the council area, and resolved that open petition, the government may be requested to continue the status quo for a period of 3 years till the consensus is emerged. Full stop. Unquote. Paragraph. Counsel for the petitioner refers to section 3 bracket 4 of the WODC Act 2000, which mandates as under reproduce subsection 4 at page 13. Full stop. Counsel for the petitioner therefore urges that the government of Orissa must, the government of Orissa, having already consulted the WODC, should now notify the precise place where the headquarters of the WODC will be located. Full stop. He points out that the present headquarters, which is at Bhubaneswar, would be inconvenient for the representatives and members comprising the WODC. And the purpose of the statute would also be defeated. Paragraph. Mr. D.K. Mohanty, learned AGA, submits that the very object of section 3 bracket 4 of the WODC Act is to ensure that the decision to locate the headquarters of the WODC is arrived at by a consensus. Stop. According to him, section 3 bracket 4 of the WODC Act has mandated consultation with the WODC for the purposes of such consensus. And since no such consensus as at present is able to be arrived at, the WODC is decided to continue the status quo for a period of 3 years from the date of the meeting. Paragraph. The impugned order of the Chief Secretary tellingly notes, open quotation, the location of the headquarters of WODC has been an emotive issue. Full stop, unquote. The WODC comprises in terms of section 3 bracket 1 of the WODC Act, districts of Bargarh, Balangir, Baudh, Devgarh, Jharsuguda, Kalahandi, Nuapada, Sambalpur, Sonpur, and Sundargarh. And open quotation, any other areas may be prescribed, unquote. Under section 4 of the WODC Act, the WODC consists of two members of the Lok Sabha representing any constituency within the council area, about to be nominated by the government on rotational basis. The 11 members of the Odisha Legislative Assembly elected from any constituency within the council area, again to be nominated by the government on rotational basis. And C, 10 experts to be nominated by the government from amongst persons with special knowledge of planning, finance, accounts of government, or wide experience in public administration or social service, or special knowledge in different fields as specified therein. Full stop. The Revenue Divisional Commissioner of the division, open quotation, under which the maximum portion of the council area is situated, unquote, and the Chief Executive Officer, who is also to be the member secretary of the WODC, is also part of the WODC. Paragraph. From the impugned order of the Chief Secretary, it appears that in compliance with section 3 bracket 4 of the WODC Act, the CEO of the WDC was asked to appraise the meeting of the latest developments regarding fixation of the headquarters of WDC. Full stop. It is seen that the petitioner was insisting on location of the headquarters at Sambalpur, which was the biggest town in Western Odisha. Whereas the WDC at a meeting held on 30th December 2022 could not arrive at any decision regarding fixation of the headquarters. So stop. It appears that the MLAs of Bargarh, Devgarh, Khariyar, and Patnagarh suggested that it should be established open quotation at their respective district headquarters. Unquote. It was generally acknowledged that no consensus could be arrived at on the issue. And so, open quotation, the council resolved to continue with the decision taken in the council meeting held on 27/12/2021 regarding fixation of headquarters of WOTC. Full stop. Even at that meeting, since consensus was unable to be arrived at, it was decided that the government should be requested to continue open quotation the status quo for a period of 3 years till a consensus emerges. Unquote. Right. This court cannot possibly compel the government to locate the headquarters in a particular place within the WDC area. Full stop. It appears that the said decision, in terms of section 3(4) of the WDC Act, can only be in consultation with the WDC. Full stop. If those comprising the WDC, namely the MLAs and MPs, are themselves not able to agree upon any particular place for locating the headquarters, it cannot be expected that the government will overlook the request for continuation of the status quo and unilaterally decide to locate the headquarters in a place of its choice. Full stop. The legislative intent, which informs section 3(4) of the WDC Act, is that the views of the WDC as regards the location of the headquarters should not be ignored. But given the above developments, the court does not consider it so given the above developments and given the legislative intent behind section 3(4) of the WDC Act, the court is unable to hold that the impugned decision of the Chief Secretary dated 23rd February 2023 requires interference. Full stop. Paragraph. It is clarified that it will be open to the petitioner to pursue the cause closer to the expiry of the period of 3 years, during which the status quo has been requested to continue. The writ petition is disposed of the workplace.
Item number 7.
Some of the land is my lords is Gochora. And the Sarpanch Malor, without conveying the Gram Sabha Malors, decided to dig the above pond in the Gochar land Malors. And we have submitted representation by the annexure 2 Malors to the collector Bhadrak Malors. And that is still pending Malors.
All right, the petitioner's representation, bracket annexure 2, will be examined by the collector Bhadrak, and after notice to the petitioners and opposite party number 3, and after giving the hearing, the reasoned order shall be passed not later than 1st July, and be communicated to the parties within 2 months, within a week thereafter. The court clarifies it is not expressed in view.
Item number 8.
Your pleasure, Lordship. The opposite part number 5, 6, and 7. They are blocking the water drain. There is a public water drain and making their personal road.
All right,
And the
petitioner's
representation
representation annexure 4 shall be
pending with the
examined by the collector
Bhadrak.
and after notice to petitioners and opposite parties 5 to 7 and giving them a
They
hearing.
have also submitted the same to the Tahsildar. It
No,
is better
Tahsil.
that Tahsildar should.
All right, by the Tahsildar.
Tahsildar.
Bhadrak.
And after notice to petitioners and opposite parties 5 to 7 and giving them a hearing, the reasoned order shall be passed not later than 15 July and be communicated to the parties within a week thereafter. The court clarifies it is not expressed.
Item number 9.
Personal appearance may be given to the petitioner.
Item 9.
May it please, Your Lordship. Now here the petition is the Sarpanch of Gram Panchayat. Under Annexure 1, the collector issued the public notice inviting objection for renewal of license, my lord. Here, pursuant to that, they have passed a resolution in the Panchayat and under Annexure 2. And thereafter, without deciding that, because it is in the schedule area, Section 27 says that without approval of the Gram Panchayat, license shall not be granted. Here, under Annexure 3, the collector has granted the license. Contrary to the government policy decision under Annexure 4, Lordship kindly have glanced page 27. That is 4.2.14 of the excise policy.
Just say notice,
Right.
he accepts notice for 1 to 4, notice to opposite party number 5 by registered speed post returnable on the next date. The tracking report will be placed in the court. List on 5th July.
Lord.
Item number 10. Item 10.
Here the petitioner challenged the illegal construction of the petrol pump by Bharat Petroleum Corporation. And here the annexure 1, page
Section 3, sir.
Page
Petitioner's representation,
18 is
Section 3.
may please be taken into consideration.
Exam.
That minimum distance.
1 minute, sir, just listen. Will be examined by the Bhubaneswar Development Authority.
BDA, Bhubaneswar Development Authority, and
BDA, and after notice to the by the secretary BDA.
I have given representation to
Yeah.
BDA and also
And after
PMC.
notice to the petitioners and opposite party. 6, opposite party number 6. And after giving them a hearing. And representative, you say opposite party 6, and after giving them a hearing, a reasoned order should be passed. Not later than 1st August 2023. The copy of this order it is made clear that the court has not expressed any view on merits. A copy of this order be sent to the Secretary BDA forthwith by the petitioner. The petition is disposed.
Item number 11.
May it please, Your Lordship. Here, the second round of litigation, Lord. At page 59, the Lordships have directed that the government to consider with regard to grant of on license, Lord. Pursuant to this order at page 59, government has not taken decision, and in the meantime, the government has issued the excise policy stating that there will be no liquor on shop in rural area. But in spite of that, collector has issued public notice inviting objection under annexure 16, my lord.
This
And my lord-
application is not covered in the new excise policy. It is a old
My lord,
excise policy.
No, my lord.
My lord,
Please
here
do
I
not,
have,
mislead
Lord,
like
I'm clarifying. Lord.
Here-
It is
here I
a
have
old
a-
policy, and as per old policy, all old applications are dealt with,
Yes.
and it is one of that old
Yes.
application, and the government has decided to extend the time period for 3 months, what I
No,
already.
that is your lordship's order.
Lordship,
So,
my lord,
without
that is a
doing
public
that-
notice, public
That-
notice on 12th April. As it is scheduled area, Lordship knows 30 days is the objection period. That has not yet come to end, my lord. 12th
Premature, sir.
Premature.
Lord, we have filed, my lord. There is resolution has been, my lord.
Court. Why
Lord,
rush
we
to
have
the
filed
That objection
resolutions.
period has not yet.
Why rush to the court, sir?
No, no, when the lordships have directed the government to consider, no, no, one, that
You-
matter is
when did you
pending
set
and
the-
has not been decided.
You
Collect-
set your objections when?
Yes.
No, no, I have raised,
no, when?
annexure 17, my lord.
When?
No, no, my objection is 17-4.
And we are only on 1st May.
Yes, 12th May is
When
the
did you
last.
file this petition?
No, no, I have filed on 24-4.
So without even a week waiting, you simply come and file
No,
a
they're not, my lord, because, my lord, that is the lordship's direction.
No.
They are not complying that.
1 week, sir. You don't even give them 1 week
No,
to
no,
consider.
my lord, I understand your lordships. No, but why the public has notice has been issued when the direction has been given to the government to consider
The
that?
petitioner's
that-
objections were filed
Lordship,
on 17th April 2023, and with hardly a week has passed when the present petition was filed on 24th April 2023. It appears to the court that the petitioners have unnecessarily rushed to the court prematurely without
And-
giving sufficient time to the government.
And this case is covered under the old policy. That may kindly be noted.
No, that is there. That I'm not disputing. That the lordship's
has to
order
be-
is there.
That has
That is to be
recorded.
decided by the government. I'm not saying.
It says that the objections will be considered in accordance with
Yes,
law.
my lord.
Yes,
Old policy,
old policy.
That is in accordance with the old policy.
Yes, ma'am.
2022-23.
After hearing the petitioners,
Yes, yes.
the excise
I'll-
commission will
Sarpanch
pass
is
an order.
here. Also, Sarpanch is here.
My lord,
Order has come.
if this type of objection, the personal hearing will be there will be no end, because number of, your lordship may direct, we will hear him, but this type of objections are,
But here resolutions are-
personal hearing should not be entertained. That is my
One representative of the petitioners to be chosen by them.
My lord, out of
It's a schedule,
11,
lord.
my lord,
Sarpanch has objected.
out of 11 members, 8 members, they have given their consent last year also, and basing upon that
That the
resolution, your lordship was
superintendent will
pleased to
take care
dispose of the earlier application.
If my lord, my friend
and
is saying
after
that,
hearing-
then it has
after
already
hearing
been rejected by the
Pradeep
government.
Kumar
No, last occasion I'm talking about.
Bracket petition number 3 was sworn the affidavit in support of the petition, as well as opposite party number
5, my lord.
Lord, 5.
5. A reasoned order shall be
Lord.
communicated. A reasoned decision shall be communicated to the petitioners
Lord, obliged.
within a period of 4 weeks from today.
Lord,
Till
Lord.
June is the last date, my lord, because
June is
3
the last-
months
this
time
has
has
to
been
be done
extended.
4 weeks, my lord,
expeditiously.
is sufficient.
Yeah,
4
within
weeks
a period of 2 weeks from today. Or, yeah, or in any event, not later than 22nd May.
Lord,
2020.
They
obliged.
will do it expeditiously, because the day is expiring in June 31st. That thereafter no application.
No, already, government has already started hearing, my lord. Here, the lordship's order is there. That's why I'm asking, lord. Otherwise, I would have said that no case is there.
All right.
Item number 12.
Item number 12, my lord, my senior, Mr. Mihir Desai, has to appear in this case. A certain personal difficulty may be taken up tomorrow or day after tomorrow.
I don't know how a PIL can lie against all these respondents, sir.
That ground we have taken because
What?
this Meta is the platform through which
How is the
we
PIL against them maintainable? Even the writ petition is not maintainable.
may be taken up tomorrow so that my senior may
No.
clarify. My lord, maybe taken up tomorrow or day after tomorrow. We have taken grounds and we have also compiled with the judgments. Sets of judgments may be taken up tomorrow.
No. See, the 3 respondents, I think you'll have to withdraw this and file a proper one. Sir.
Maybe
Three
taken up tomorrow. My senior will just,
You first answer, sir.
my lord,
Look at the opposite parties.
my lord.
The first one is in California, second one is in Boston.
All are private opposite parties,
How
companies.
should PIL lie against private opposite parties?
My lord,
So fundamental. How is a PILs, this is 226 petition, sir.
My lord.
How will it lie against
But
private
they are
opposite
performing,
parties?
these companies are performing public functions. My lord.
Please.
My lord.
In California, they're sitting and
No, my
performing
lord.
public functions.
My lord, the Meta is the platform.
No.
Meta, through Meta, Facebook, Instagram,
You have
WhatsApp is
not
being
applied
used.
your mind to this, sir. You're just, we are not going to entertain writ petitions against private opposite parties.
Maybe taken off tomorrow, my senior will appear and, my lord, Passover
Passover is
my lord.
Item 13.
None appears dismissed.
Item number 14.
Let I pray 7 days time to file the certified copy of the impugned order.
Not, it's a 2016 matter.
Wrongly, it has not been filed.
No.
The Xerox copy has been
For the
filed.
last 6-7 years, even the certified copy of the impugned order has not been filed.
My lord, my lord,
The court does not propose to grant any indulgence in this regard, considering it's a writ petition that's been pending since, writ appeal since pending since 2016. The appeal is dismissed for non-prosecution.
Item number 15.
my lord,
None appears dismissed.
Item 16.
None appears dismissed.
Item 16. My lord, item 16 that is covered by your lordship's judgment, my lords. I have given the reference, my lords.
What reference? What reference?
Item 16.
16.
Yes, that is covered by your lordship's judgment, my lords. That is that is WA number 239 of 2018.
March 2023.
That is a one-time tax matter, my lords. Your lordship already disposed of.
Judgment. In WA number 239 of.
Sir, neither of you thinks it necessary to give us copy of anything.
Lord, he has not served copy. Just
He has
now,
not served. You don't have
just
a
now
copy.
she served.
Huh?
Just now served the copy of the writ appeal. That is why I have gone through that.
Copy of judgment, my lords.
Hmm?
I have got the copy of the judgment.
Very good, sir. That's excellent news. Would you want to share it with us or not? In view of the judgment dated. March 2023, passed by this court. In WA number 239 of 2018. The present appeal shall stand allowed in the same case.
Item number 17.
None appears dismissed.
Item number 18.
Permitted to withdrawal.
Dismisses withdrawn.
Item 19.
19, no instruction.
No instructions dismissed.
Item number 20.
may I please your lordship? Lord, the impugned order is page 77, answer 3. That is the court had ordered 24 issue a notice to the appeal party, but feel that requisite has not been filed for extension notice with the said appeal party. Therefore, this court is not inclined to grant further argument in the matter. Accordingly, the petition stand dismissed for non-compliance with order. And therefore, we file the miscase for restoration, and that was also dismissed at page 90.
Yes. Correct only.
And there are five petitioner in this case, in the double PC number, and other 4 application also filed the writ appeal. That is matter also pending for the Honorable Court. Sorry, there number of the petitioner is there, and out of there, some of the petitioner also filed the writ appeal by W number 17 by 20. And that matter also issue notice to the opposite parties. It will go along with this petition.
No. Some other order, sir.
No, same.
No.
The writ petition number 5031. Double petition number 5031 by 2006. The petition number 12 is the myself, Sumitra Bihari. But other petition number 1.
Where is this matter now pending? 17? Where is this writ appeal 17 pending? It's pending here.
Yes, ma'am.
List tomorrow. List along with writ appeal number 17 of 2020 tomorrow. They've wrongly noted that some interim orders vacated and all that. This 2012-2019 is dismissing an application for modification or recall. Correct?
Yes.
In this order, which you handed over, it is noted that the interim order passed by so-and-so was vacated. List along with writ appeal number 17 of 2020 tomorrow. Disposed of by what?
At January 2020.
Oh. That's been dismissed. You say counsel for the appellant relies on an order dated 16 January 2020, passed by the division bench of this court, issuing notice in writ appeal number 17 of 2020, which is directed against the order dated 20th December 2019 of the learned single judge, dismissing IA number 17614 of 2019 in writ appeal in writ petition civil 5031 of 2006. Full stop. The court notes that on 3rd January 2023, the said writ appeal 17 of 2020 has been dismissed by this court by a detailed order. So consequently, the present writ appeal, which challenges the same impugned order of the learned single judge, is also dismissed in the same terms.
Item 21.
May I please note. Your Lord, the appellants are the opposite parties number 2 to 4 of the writ petition, my Lord. My main ground of challenge of the impugned order is, my Lord, the present appellants were not noticed in the case, my Lord. My Lord, copy of the writ petition was also not served till after filing of the
order, sir.
My Lord.
Some innocuous order of looking into the representation, that's all.
My Lord.
Come to the impugned order.
My Lord, that is
very innocuous. The impugned order contains an innocuous direction to look into the request of the writ petitioner, bracket, respond number. Here in which respondent?
Here, my Lord, respondent number 1.
1. And pass appropriate orders. Full stop. Since the direction is innocuous, the court does not consider necessary to take care. The petition is, the writ appeal is dismissed.
22.
My appearance may be noted. I am opposite but now 2. You know.
22 by Sarthapada 11th May. 8th May, sorry.
8th May. This is first day.
First day. All the matters.
Are you agreeable?
My lord, in earlier occasion, the state has challenged this order.
Your colleague walked away. Whom is he appearing for?
He is not an
Previous matter.
He 21.
He's 21. I am 22.
All right.
So all these matters can come on the 11th, 8th May. On that day, you will pass that.
Same order.
No, my lord. In earlier occasion, the state has challenged the said order.
8th May रे आसियो आपन.
एटा WA थरे करि करि देइछन सिंगल बेंच को.
एटा कोज फ्रेश मैटर माने एटा आसियो 8th May रे आपन को सब मैटर गुडा को.
फ्रेश गुडा.
Single list on 8th May.
8th May को आसियो.
Double filing.
Item 23.
Double filing.
23, 25, 9.
24.
No, please.
Item number 25.
25 matter. Sorry. Please.
But I prefer 10 days time to remove all these defects.
21 matter, sir. The 2021 matter.
Miller, last chance may be given, 10 days time may be given.
What's the matter about? Let's. No, that's already there. Have you seen the 21st February order? Do you have the order? 21st February.
No, Miller, no.
See, that's very convenient, sir. We have a problem. We see our own orders. You are very happy because you don't see any order. Just show him the order. The best thing for counsel to do is never read the orders passed in his own matter. Then everything is sorted out.
Sorry, my lord.
Even we are sorry. What to do? This was listed. We passed an order in your presence.
This is my prayer before my lords, my lord.
No, you yourself appeared or somebody else appeared?
No, I had not appeared. My associate.
Oh, your associate. Your associate doesn't tell you what orders are passed. All right. Despite a last opportunity granted on 21st February 2023 to remove defects, till date defects have not been removed. This is a 2021 writ appeal. The court does not propose to grant any further indulgence in the matter. Dismiss for non-prosecution.
Item 26.
I may please your lordships. But here is a case pertaining to the promotion of the petitioner appellant before the tribunals from the post of stage 1, assistant professor stage 1 to stage 2. That's with effect from the date on which he has awarded with degree, PhD degree. My lords.
The defect. Did you note what the defect is?
Yes, I have not.
Not so convenient, sir. Why only we are reading all this? You don't have to read all what is written in the cause list.
Yes, yes. That I may be
read it, not read it.
Sorry,
what is the defect? Tell me.
Yes, the defects. Bhinama not filed. Vocalatnam not filed.
Is it important or not important?
I may be
important defect or not important defect? Vakalatnama not filed.
Yes, sir. I'll.
When, sir? It's 2021.
Yes.
Only 2 years have passed. For 2 years, you've not filed Vakalatnama.
Yes.
This is the only High Court, sir, where non-filing of Vakalatnama also no problem. Matter will be listed.
Yes, sir.
This is the only High Court. So, I have practiced in 3 courts: Supreme Court, Delhi High Court,
Punjab and Haryana High Court.
Sorry. These are all serious defects. For the last 2 years, the counsel of the petitioner could not find time to even file his own Vakalatnama.
I may permitted to file within a week.
He now wants further adjournment for that purpose. The court is not inclined to grant this adjournment, considering it's more than 2 years since the petition appeal was filed. Dismissed for non-prosecution. All right.
Item number 27.
11th of May, my lord, promotion during vigilance proceeding, my lord.
All right.
28.
30th of September, my lord, rehabilitation assistance.
Right.
Item 29.
May I please, Lordship, kindly see page 14 is the impugned order, my lord. Here the case of the respondent was that in absence of CCR, he was
Before
not given...
the London State Council makes an argument, I must bring to my notice, probably my learned friend is not knowing that the promotion they have already given to the private respondents. They have, that's the order. I don't think they will be any more aggrieved.
So then let me at least verify.
I'll serve a copy.
No, I didn't know this. Since my learned senior is giving this now.
Mr. P.K.
Dated 27/12.
I have given a mark, serial number 2 and 4. I am serial number 2 and 5.
Yes, I'll take instruction upon this matter for the respondent. There are 3 matters.
2. I am concerned about 2 only. 29 and 30.
Has produced a copy of an order dated 27th December 2022, issued by the Collector and District Magistrate Mayurbhanj, implementing the impugned order of the learned single judge. In that view of the matter, the present writ appeal has been rendered infructuous. It is clarified nevertheless that the question of law raised will be considered.
That's right.
In some other case. The writ appeal is dismissed with the above observations.
There are 29, 30, 31.
All 3.
All 3 are covered with this.
Right.
Item 32.
32 minute rehabilitation is 38.
38. Correct.
Item 33.
Minute regulation matter 25th of September.
All right.
34 same minute.
25th September.
Minute.
Item 35.
35 minute not placed.
All right.
Because that is not, I cannot justify.
All right.
Sorry.
All right.
Item 36.
May I please, Your Lordship? My Lord, here, this is almost akin to the one yesterday Your Lordship dealt with regard to restoration. But here, my Lord, the petitioner, original petitioner died. Since this is my matter with regard to service benefit, because there has been a termination, the legal heirs filed a CMFPL application. That 2019 it was dismissed. 2020, my Lord, in fact, they came to know 2021 they filed. Similar to one yesterday, my Lord, AST Mr. Padhi was there. This is here also the union is there. But here, my Lord, I am praying for a hearing. My Lord, similar kind of facts. Rather, here the delay is little less than yesterday, which Your Lordship was pleased to deal with. And my learned friend Mr. Padhi was very magnanimous in saying that the matter should be had in merit, and Your Lordship considered that. Here, Your Lordship will see, my Lord, this CM 2019, he brings the file. He was having some mental ailment. So he couldn't engage a counsel, and 27/9/2020, he died. My Lord, the petitioner, original petitioner. Now the heirs are before Your Lordship, they have a lot of sufferings. I am only praying for a hearing on merit, my Lord. My friend is there, my Lord, online.
Let it go back, sir.
Yes, my Lord.
All right.
697 delay, my Lord, there.
All right. You see, the present appeal is directed against an order dated 26 November 2021. Passed by the learned single judge, dismissing CMAPL number 274 of 2020 and IA number 118 of 2021, whereby on account of the delay of 697 days in filing the restoration application. The restoration application was itself dismissed. Paragraph. The writ petition civil 3606 of 2004, filed by the original petitioner. Number 1, is it? Because there are several writ petitions.
The original petitioner is one petitioner. The heirs are before Your Lordship.
No, filed by the petitioner, original petitioner, bracket, whose legal representatives are the present appellants, bracket, was dismissed for non-prosecution on 3rd January 2019. Full stop. In seeking recall of the said order, the present appellants filed IA number 118 of 2021, accompanied by an application for condonation of delay.
May I humbly clarify one thing?
Oh, no.
CMAPL was filed for restoration with IA for condonation of delay.
Oh, I see. Filed CMAPL 274 of 2020, along with for condonation of delay. No, for restoration. Sorry, for restoration of the said writ petition. Full stop. In the said application, it was explained
with Your Lordship's permission, IA was filed for condoning the delay in filing the CMAPL. IA 118 of 2021. Paragraph 5.
Yeah, along with 118. Yeah, along with IA 118 of 2021.
Oh, right.
For condonation of delay of 697 days in filing the CMAPL. Paragraph. In the said IA, it was submitted that the original petitioner was suffering from certain mental health issues. And wanted to change his counsel, but was unable to do so prior to his death on account of his illness on 27th September 2020. Stop. His LRs then inquired about the matter and came to know of the dismissal of the writ petition, which was not within their knowledge earlier. Paragraph. It was explained that the LRs were in a dire condition and therefore pursuing the writ petition was important for them. Paragraph. The court, having heard learned counsel to the parties and considering that the original writ petition itself was questioning the termination of the services of the writ petitioner, and therefore it is important. And with the pleadings having been completed, it was necessary to hear the writ petition on merits. Stop. The outcome of the writ petition would matter to the LRs of the original petitioner, who are in a dire financial condition. Paragraph. In view of the above factors, the impugned order dated 26 November 2021 is hereby set aside, and CMAPL number IA number 118 of 2021 is allowed by condoning the delay in filing CMAPL number 274 of 2020, which also would stand allowed, which also stands allowed. Stop. As a result, the order dated 3rd January 2019 will on single judge dismissing WP Civil 3606 of 2004 stands recalled, and the said writ petition is now restored to file and directed to be listed for the roster bench of the learned single judge on 6 July 2023. Paragraph. The counsel for the present appellants as well as counsel appearing for the contesting respondents will appear before the learned single judge on that date and not seek any further adjournments. We'll stop. Considering that the pleadings in the writ petition are already complete, the learned single judge is requested to proceed with the hearing of the writ petition on merits and dispose it off as expeditious as possible. The writ appeal is disposed of in the above terms.
My lord, appearance be noted, Union of India.
Yes, yes.
Okay. Item number 37.
Rehabilitation appointment scheme, my lord, 30th of
August.
I have entered appearance. Let the copy of this order.
Yes.
All right.
By tomorrow also.
Item number 38.
38, 39, 40, 41 was Sartapada, 8th of May.
All right. Just simply say list on 8th May.
Item 42.
42. May I please, Lord? Lordship, kindly see page 46 is the impugned order, my lord. Here the respondent had approached the learned State Education Tribunal, my lord, under section 24B for a direction for approval of her appointment with effect from 17/8/93, my lord. The learned tribunal allowed her application, my lord. That order was challenged by the state in an FO. That FO was dismissed not on merit but on limitation ground, my lord. Thereafter, the government passed an order with a condition that she will be given the benefit 3 years before she approached the tribunal, my lord. In view of the decision of the Honorable Apex Court in the case of Tarsem Singh, my lord. That communication was challenged by the respondent before this Honorable Court, my lord. The learned single judge, my lord, took note of the submissions. The finding was that since the FO of the state has been dismissed and she has been given relief by the tribunal, that ought to be extended to her. That's the only ground. But Lordship, kindly see, my lord, the Tarsem Singh case, subsequently also in 5 other cases, my lord, we have mentioned in a ground, my lord, that has been taken note by the Honorable Supreme Court. That's a law laid down, my lord. In case of money claims, my lord, if it is belated, my lord, it ought to be, my lord, not entertained at that stage, my lord. Here, the respondent has approached the tribunal after 11 years of her joining the service. Lordship, kindly see, my lord.
No, is a contempt petition filed or you have not implemented the impugned order?
No instruction about contempt, my lord. here the cause of action arose in 83. She approached the tribunal in 2011, after 18 years.
But she had succeeded in the first round.
Yes, my lord.
You didn't challenge that education tribunal order?
Yes, we have challenged an FO that was dismissed not on merit but on limitation grounds.
Whatever. Once it was dismissed, that attained finality.
That has attained finality.
Then you have to implement it, sir.
My lord, only that
you could have challenged either before the division bench or the Supreme Court. You didn't do that.
No, we had challenged that,
law.
but the liberty was given by the Honorable Appeals Court to approach your lordship. That we have done.
Where is that?
My lord, lordship, may kindly see we had approached the Honorable Supreme Court in SLP number 120.
Oh, and then you filed this writ appeal.
Yes. So thereafter, this appeal has been filed, my lord.
Oh, all right. You see, it is seen that the present appeal has been filed as a result of the liberty granted to the appellant by an order dated 20th October 2021 of the Supreme Court of India in SLP civil number 120 of 2021, whereby the appellant had challenged the order dated 12th February 2020 passed by the Honorable Single Judge, allowing writ petition civil 27147 of 2017. Paragraph, notice returnable. Notice on the IA as well. And the IA for delay, IA for stay. Notice on all of that. Now, dispensing with is allowed. There is also an IA for stay. So notice on all three. Writ appeal, IA for delay, IA for stay. Returnable. 17th August.
Grateful one. Item number 43.
May I please? But some facts have been pointed out. I will be permitted to remove the defect within 2 days and
2021 matters.
Yes, and I am ready in merit, Lord.
Yes.
That I am challenging the impugned order at Annexure 14. That without issuing notice to the institution, though the opposite part number 3, Lord. At the stage of admission, the writ petition was disposed of, and an order has been passed to upgrade the appointment of the respondent number 1 to the post of estate manager, though he is not eligible to be appointed in that post, Lord, without being appearing in a selection process. Your lordship can see the selection process to the post at Annexure 2. Your lordship can see at page 42. But no notice was issued to the college, to the institution, and the writ petition was disposed of at the stage of admission. On the basis of the documents filed by the petitioner.
What has happened in the last 2 years?
Last 2 years, we have not given up. We have not promoted and we have not considered. We have filed this writ appeal challenging that.
No, but has he filed a review, or contempt?
No contempt has been filed.
Then?
No contempt has been filed.
Then why should we unnecessarily entertain this?
Let your lordship can see he is not at all eligible to be appointed in that post.
He's not coming forward. He's not filed a contempt.
He has not filed the contempt, but your lordship can see the court, the Honorable Single Judge has directed that you should take decision to upgrade his appointment to the post of estate manager.
No. Is he working or he's left?
No, he is working.
Then how come he's not interested in upgradation of his post?
Upgradation because he was officiating in that post.
No, he's not interested. He's still working with.
No, he's interested. He has gone to the to the government for that Lok Adalat.
What will Lok Adalat do?
Lok Adalat for appointment.
He has gone to the Lok Adalat. He has
promotion Adalat. That is a promotion Adalat. He has approached to the promotion
After
Adalat.
Getting an order in his favor, he has gone for promotion Adalat.
He has gone to my instruction today morning, Millard, that he has gone to promotion Adalat. It is not a promotional post. It is a single post advertised in 2011.
Suppose he gets promotion in that promotion Adalat, then what happens? You say counsel for the appellant states on instructions that the respondent has approached the single court's promotion Adalat, court of the government, paragraph. The counsel of the appellant will inform the court of the outcome thereof.
Yes.
On the next date, defects be cured in the meanwhile. List on 7th August. None appears dismissed.
Item 45.
My item 45, 46, Sarta part, 8th May.
Simply say 8th May. Okay.
Item 47.
At 47, I may permitted to withdraw with liberty to file a review.
Review. Dismisses withdrawn with liberty to file a review petition.
Item 48.
48 on my prayer, your lordship had ordered the other matter, which was the main matter, 1025 to come along with this. That has not come up. So I pray that will come up next week.
And again, the same thing is happening. Why was it not listed? (1025), we give a date for today.
Yes, my lords. Your lordship had passed orders that should be listed today along with this, because 1026 had come up before your lordship yesterday. When I mentioned, your lordship passed orders.
There. So we'll take it up on special notice. Same thing only.
Your lordship may, since I pray for some time to get ready with the original.
Why? Yesterday and today you could have got ready, sir. These are not such very complicated matters.
At least your lordship may call it tomorrow. I'll get ready.
No. Why not, sir? We'll just, if you want to see the paperwork, we'll get it from the registry.
No, I have that writ application with me. But
then we are happy.
Since the original writ application,
so you see the list. If it is not listed, you say, let me not get ready with the matter.
No, not exactly. I bow down to what your lordship
then
says.
you're ready with the matter.
No. I have gone through the matter, but it's a bit complicated. So
no, it's all right. We will also help you, sir. Start.
Your lordship may call it tomorrow.
No, sir. We have some problem. You carry on.
This writ appeal number 1025 was directed against, has been filed against the order of the Honorable Single Judge, where it related to the respondent number 1 having been absent unauthorizedly from service for the last 5 years. Thereafter, so-cause was issued. And opportunity was given, but the respondent number 1 did not participate, did not cooperate. And thereafter, on an undertaking of the university before in another writ application, that was disposed of to be finalized within a particular time. Thereafter also it was, accordingly, he was noticed, but all through he did not cooperate. And thereafter, when this particular writ application was heard by the Honorable Single Judge, he was of the opinion that the Lordship was of the opinion that reasonable opportunity has not been given, and the contemplated punishment has been stated in the show cause. That was the reason where the writ application was filed. Writ appeal was filed on the grounds. Your Lordship may kindly come to page 11 of the said writ application. The Honorable Single Judge had held that the issuance of the so cause was found the illegality in the issuance of the so cause, and that which was not tenable in the IF law. That is the stand taken herein. And thereafter, the reason was that the Vice Chancellor, being the disciplinary authority, having conducted the inquiry or having assumed the role of the inquiring officer and the marshalling officer, is not permissible in the IF law. But under service rule, Rule 15 of the Orissa Civil Services Classification Control Appeal Rules, 1962, which as stated herein, it reads as follows.
Where is it? We'll just pass it over. Let 1025 be brought. 1025 is against some other respondents.
No, the respondent is the same, but two separate writ applications heard together. First one was as regards the illegality in the issuance of so cause. Second one was resigning of the leave salary, which is before your lordship now, 1026. The parent one happens to be 1025, my lords.
No, what is challenged in this writ petition, in this, I mean, out of which the present writ appeal arises, are two orders. One is rescinding the joining report, and the other is granting sanction of leave, increment, etc.
So that is 1026 before your lordship. That is limited to the in 1026, but the original one was of which was numbered as 1025. That is as regards the so cause having been issued on the respondent being absent unauthorizedly from service for last 5 years. And the Honorable Single Judge, while disposing of the matter, adjudicating, the ground taken herein was in 1025 that the ground taken in the counter affidavit has not been taken into account by the Honorable Single Judge on the ground that the Vice Chancellor being the disciplinary authority cannot be the marshalling officer. But that exactly is not correct, because the Rule 15 states about certain things where the disciplinary authority can also be the inquiring officer. That is what I have taken the ground in this writ appeal. That was also taken in.
But what happens? Only you are given a permission to do it correctly, correct?
Rule that was quashed. That particular show cause was quashed, and he was the university is now aggrieved and is before your lordship. He is to be given all his retirement benefits. That's all right, but with 5% interest. So that exactly was
what is 5% interest? Nothing.
That exactly was the crux of the matter. Your lordship,
man is 67 years old now. 67 plus 3 more.
2 more. What I plead before your lordship is an erring official who has been on an unauthorized leave for last 5 years in a government job.
Yes.
And that too, it's a state university. Your lordship may kindly consider even the expenses for official stationery is to be sanctioned by the government. So at this point of time, the Honorable Single Judge having ordered that the payment of 5% interest along with all other benefits is naturally overbearing on the university. So that exactly is the point why this writ appeal has been filed before your lordship by the university.
And we will ask for the file. Pass over. Let the writ appeal 1025 come.
Item 49.
At 30th August, my rehabilitation.
Item 50.
Sartapada 11. 8th.
Item 51.
My lord, item 51, my lord, I have filed the Wakalatnama today, my lord. Let it come, my lord.
Yes.
Here, my lord, I am challenging the order of the Honorable Single Judge, where the Honorable Single Judge has said that the cinema hall license has been granted in favor of the individual. Instead of, my lord, our prayer was to cancel the license because it is not an individual cinema, a proprietorship cinema hall. It is a partnership cinema hall. The finding of the civil code is there, my lord. Page 113, your lordship may kindly see. It is established that plaintiff and the husband of the defendant number 2 are also partners in the firm, of which defendant number 1 is the managing partner with equal shares as per the exhibit 9, my lord. My lord, when this finding of the civil court is there, the opposite respondent number 3 applied to the collector Kondamala for cinema license, and she was given license under annexure. Lordship may kindly turn to page annexure 20 at page.
What is there to show there is a partnership firm?
My lord, this civil court finding is there, my lord.
What civil court finding?
And page 113, your lordship may kindly peruse. The cinema is a partnership firm. And the licenses already granted previously, your lordship may kindly see page 68, where the license was granted, renewal of the cinema license number 7 of 92 of Shraddhanjali Talkies, Fulbani. It is a partnership firm.
No, where are you reading?
My lord, page 68.
No.
Of the read appeal, my lord. Your lordship may kindly see page 57, where the my lord, additional district magistrate Fulbani has written a letter to Anil Kumar Behera, managing partner, Messrs. Shraddhanjali Talkies. My lord, for renewal of the license, I am directed to inform you that the licensing authority has been pleased to renew your cinema license number so and so, subject to deposit. Everywhere, my lord, it is a license to the.
What's the order passed by the civil court that you are not showing?
My lord, civil court 113, your lordship may kindly see, we have filed for declaration that the cinema is a partnership firm. And issue number, while deciding the issue number 3 and 4, your lordship will find it starts from page 112, and the finding was that it is established that the plaintiff and the husband of the defendant number 2 are also partner in the firm, of which defendant number 1 is the managing partner with equal shares. Defendant number 1, here the respondent number 3. The collector, my lord, instead of granting license in favor of the cinema hall, Shraddhanjali Talkies, has granted license in favor of the respondent number 3.
All right. You said right now he's continuing the cinema hall.
My lord. That is the difficulty, my lord.
The suit is ultimately dismissed.
No, suit dismissed, but finding is there. He has not challenged the finding.
But the law is that my learned friend knows that any finding in a suit which is ultimately dismissed, that has no force at all.
No. So far as the finding of the trial court is concerned, civil court is concerned, unless and until that portion is challenged and set aside, that finding will remain continued.
Will be challenged
Even if
your suit is dismissed.
I think the single judge says there's nothing to show that there is a partnership firm.
Yes.
So but for that purpose, he's referring to the judgment.
My lord.
Which is on contest. All right. According to counsel for the appellant,
there. Single judge said that there is no document to show.
That's why he says this is the document. Counsel to the appellant refers to a judgment dated 26 April 2011, passed by the civil judge senior division Pulwani in CS number 14 of 2008, where, while dismissing the appellant's suit for declaration, permanent injunction, and rendition of accounts of the partnership firm, Messrs. Shraddhanjali Talkies, findings were rendered on issue number 3 that the said entity was in fact a partnership firm of which the present appellants and respondent 3 were partners. So he accordingly submits that the learned single judge was in error in observing that there is no document to show the existence of a partnership firm. Paragraph. Notice, Mr. Manti accepts notice on behalf of respondent number 1 and 2. Notice will now go to the respondent 3 by registered speed post, returnable on the next date. The tracking report be placed in report. List on. Second last.
Item 52.
My lord, I pray for stay of the honorable civil judge order, my lord, because he is showing that order and taking the license.
No, it's not. Notice on the stay also.
Right. Oh, like.
My lord is fixing it to
2nd August.
Oh, like.
Item 52.
52, my lord, is covered by a lordship's judgment, my lord. This is data entry operator in Towson's, my lord.
in view of the judgment of this court in State of Orissa versus Patita Pavan Tadash.
W number 777/2021.
W777 of 2021.
777/2021 disposed of on 12/4/2023.
The appeal is dismissed. All right.
Item 53.
May I please, Your Lordship? Lordship, I mean, we have Mr. Lingaraj Sadangi. Lordship, in this case, my lord, there is defect is there. So, my lord, 10 days time is given for remove the defects. Item 53 and 54, my lord, listed for first time.
List on 2nd August. Defects be removed.
Oblige.
Item 55.
55 may please. In that case, Ministry, that the present petition challenging the order dated 4/2/2022 passed by the Honorable Single Judge Millership, which is passed in the page number 13 Millership. That is, he stated that Millership is clear that the questions cannot be asked in re-examination Millership. And
how is a writ appeal maintainable, sir?
How maintainable that in page number Millership in PW1 that was the Law and Civil Justice Senior Division has stated that the PW1, the name is Ramesh Chandra Karan, is at liberty to re-examine.
Just listen to the question.
Yes, ma'am.
How is this writ appeal maintainable?
There are grounds that they are mentioned that
How is this writ appeal maintainable?
Maintainable Millership that he has not recalled the PW1 Millership for prosecution.
I think you're not understanding the question, sir. All right. See, the present appeal is directed against an order passed.
That has been against Millership, against the CMP order Millership. The order has been passed against the CMP order. That has been allowing the application to set aside the order Millership 24/8/2017 Millership. In that case, Millership, that he has stated that the PW cannot be asked in or re-examination. And in that stated Millership that he has only that when the PW1 is examined, that he has stated that the word not written in the deposition Millership in para 26 and 27.
The present writ appeal.
I just only must clarify that in as per the Millership section 142 of Evidence Act Millership, that he has been examined Millership in the examined Millership.
I've asked the question twice. My learned colleague has asked you the question once. You have still not understood the question. So we don't want to waste our time asking you the same question again. All right.
Well, keep it in another day, Millership. I will satisfy Millership. Keep it in another day.
Adjournment will not produce anything.
Tomorrow.
No. Tomorrow. What is the question we asked you?
That if the questions will be leading questions, will be then the
question. See, that's why I'm saying. You've not even understood the question, then why should we bother, sir? No problem. You say the present writ appeal is directed against an order dated 4th February 2022 passed by the learned single judge in CAP number 1080 of 2017, which was challenging an interlocutory order dated 24th August 2017 passed by the Civil Judge Senior Division, Jaleshwar, in a petition filed by the appellant or plaintiffs in CS number 232/2014-1 stroke CS number 308/2016-1 seeking recall of a plaintiff's witness for his re-examination. Paragraph. Given the nature of the proceedings and the impugned order passed, counsel for the appellant was asked by this court thrice to explain how the present writ appeal was maintainable, since the impugned order was obviously passed by the learned single judge in exercise of the jurisdiction under Article 227 of the Constitution. Paragraph. Counsel for the appellant is unable to give any answer despite the question being asked thrice. Full stop. in view of the judgment of the full bench of this court in Mohammed Saud versus Dr. Major Sheikh Mahfouz, which was affirmed by the Supreme Court in the present writ appeal is not entertained on the ground of maintainable. Leaving it open to the appellants to seek other appropriate remedies as may be available to them in accordance with the law. The writ appeal is dismissed.
Only pray my limited prayer must be tomorrow my receipt, then I'll satisfy my receipt.
Item 56.
Item 56, my lord, caveat is filed, my lord. The 56 item, caveat is filed. I am serving a copy out to the caveator.
I am not understood.
What caveat is filed against the writ application.
So
I am serving a copy.
All right. Yes, tell us what the matter is about.
Your Lordship may kindly see that notification on page 37. Notice for appointment of regular rural retail outlet petrol pump, your Lordship, was published, your Lordship. At place Bodamba, your Lordship will find at 114 that the criteria is that the land must be lying within 1 kilometer from Narayan Chandra Hat to my lord towards Sunapal Chowk. My land was also lying. I was selected for that, your Lordships. At page 119, your Lordship will find that I was selected initially, complying all the criteria. Subsequently, my lord, what has happened? The doubt came into the mind of the corporation. For that, my lord, clarification was sought for from the Tahsildar Badamba, where also he has stated that my land is lying within that area. At page 120, your Lordship will find. For the second time also, my lord, again clarification was made. Again, Tahsildar has said, my land is lying within that area. At page 122, your Lordship. And third time clarification was made, and that was said that my land is not lying. Without the Tahsildar is stopped to say, whenever Tahsildar has specifically stated my land is lying within that area, and subsequently, my lord, on the basis of that third report, my lord, my claim was not accepted. And your Lordship will find that I had also submitted the Google map and all the things that my land is lying within that area, and for that also I was selected I was selected. But subsequently, my lord, on that reason, your Lordships, my lord, I was discarded and private opposite respondent was selected. And the honorable single judge, your Lordship, will find that that was not considered at all.
No, but your land does not fall within that.
Yes, your Lordship. Your Lordship may kindly see, I have given all the documents. Your Lordship will find that your Lordship may come to the page 120 initially. Page 120.
Page 120.
My lord, 120 of my appeal. But here, my Tahsildar specifically stated that my land is lying within that area.
Yeah, but subsequent verification.
Subsequent, my lord, second time, my lord, on verification also, my lord, your Lordship will find at page 122. Subsequent also, on clarification sought for by the corporation, 121 clarification is sought for. And subsequently also, the same Tahsildar has said my land was lying within that.
No, the third time he said differently. Annexure 7 is one thing, Annexure 9 is different.
No, my lord, page 120 is, my lord, it is lying within that area.
After that, he has changed.
That also, my lord, the same area. You Lordship may kindly say, I may be permitted to read 122. In inviting a kind reference on the subject, I am to clarify that the scheduled land is situated at the beginning of Narayan Chandra Hato while going from Bodamba town. It may be stated here that Sunapal Chowk is situated at a distance of around 500 kilometers from Narayan Chandra Hato towards Narsinghpur. That means, my lord, that is lying within Narayan Chandra Hato to Sunapal Chowk.
Now come to Annexure 9, 7, 1, 20.
Subsequently, my lord, for third time, my lord, it is stated. That my point is. While my lord, twice, my lord, Tahsildar has said my land is lying, and I have also submitted the documents. These documents were not at all considered by honorable. Your Lordship may kindly see.
Can't do more than that.
Your Lordship may kindly see. Twice Tahsildar has said. Twice. Twice, my lord, Tahsildar has said my land is lying within that area.
Right.
And for that I was selected.
Yes.
and no opportunity of hearing is given, nothing else, my lord. For third time, my lord, if my land is lying within that area, my lord, your lordship may kindly say I have given 126 the Google map also.
Yes.
That says, my lord, that my land is lying within that area. And the Amin report of the same Tahsildar, your lordship, I have submitted in the rejoinder. Your lordship may kindly see in the rejoinder also, I have given that, your lordship will find at page 186. The Amin of the same said Tahsildar has given that map, your lordship. Your lordship may kindly see page 186. And that is the original map I had submitted before this honorable court. That map also, my land is also marked therein, and it is also lying within that area. Narayan Chowk to Sunapal, Narayan Chowk to my lord Sunapal Chowk. The Amin report is there, and also the map is there also.
All right. The present writ appeal is directed against.
But nothing has been taken care of in the order. Your lordship will find the under Annexure 6, your lordship. Nothing is taken care of. Only what ground, my lord, it is dismissed, your lordship. Kindly visualize. Kindly appreciate, your lordship. The para 12 of the page 270. Looking to the other issues involved herein, this court finds the petitioner didn't attempt to block the reconsideration except being raised by opposite party number 4, and in the meantime they are involved further development selecting OP number 4. My lord, that was challenged. Though my lord, my selection was cancelled and OP number 4 was selected thereafter without considering this, my lord. And it is, on the other hand, the petitioner not only involved in the reconsideration process but also went on cooperating and got involved in an outcome. Thus, this court finds there is no substance in petitioners claiming that the initiation of second considered aspect is bad in law. But fact remains that my land is very much lying in that area. I had produced certain documents that was not at all dealt with.
Challenge the present petition appeal is to not judgment dated 25th July 2022 passed by the single judge dismissing petition civil 5005 of 2021 filed by the appellate. So 2020 filed by the appellate. Questioning an order dated 20th January 2020 passed by the head of territory, Bharat Petroleum Corporation Limited, packet BPCL. Cancelling the candidature of the appellant for the purposes of allotment of a retail outlet dealership for Badamba. District Cuttack. Parish. One of the conditionalities for allotment of the above retail outlet was that the candidate must possess land within 1 kilometer from Narayan Chandrahata towards Sunapala Chaka on the right hand side of SH 65. Paragraph. The appellant applied for the retail outlet dealership offering the land belonging to him, which according to him satisfied the above requirement, among others. Full stop. while the appellant was successful in the lottery, opposite party number, respondent number 4 did not succeed, and then filed a complaint with full stop. Respondent number 4 filed a complaint before BPCL, alleging that the land of the appellant was not within 1 kilometer from Narayan Chandra Hatta to Sunapala Chaka on the right hand side of SH 65 paragraph. On receipt of the above complaint, BPCL asked the appellant to produce a report of the Tahsildar, Badamba, regarding the exact location of his land. Paragraph. Initially, on 5th September 2019, the Tahsildar Badamba issued a letter addressed to BPCL stating that the petitioner, the appellant's land, did satisfy the locational requirement of being 1 kilometer from Narayan Chandra Hatta to Sunapala Chaka on the right hand side of SH 65. The same letter was also submitted by the appellant to BPCL. BPCL then sought a clarification from the Tahsildar Badamba by letter dated 4/10/2019. Again, on 22nd October 2019, the Tahsildar clarified to BPCL retreating the earlier position, the earlier letter regarding the exact location of the appellant's land. It appears that a further report was submitted by the Tahsildar Badamba on 7 January 2020, contradicting the earlier reports, thereby stating that the land of the appellant was not situated in between Narachandra Hatta to Sunapala Chaka. Paragraph. Acting on the aforementioned third report of the Tahsildar Badamba, BPCL cancelled the candidature of the appellant for allotment of a retail outlet by the letter dated 20 January 2020, which was then challenged by the petitioner, by the appellant, by filing writ petition civil 5005/2020 in this court. Paragraph. The learned single judge has, in the imputed order dated 25th July 2022, taken note of all of the above developments. Full stop. The lack of clarity of the earlier letters of the Tahsildar, including the one dated 5th September 2019, prompted BPCL to seek a further clarification on 16/10/2019. Full stop. This time the Tahsildar, by the letter dated 7 January 2020, informed BPCL that the plots offered by the appellant, open quotation, are not situated in between Narayan Chandra Hatta and Sunapal Chaka on SH 65. Full stop. Rather, the plots are situated in between Narayan Chandra Hatta and Badamba Town Chaka. Unquote. Paragraph. Counsel for the appellant will stop. It is the above clarification that prompted the learned single judge not to interfere with the order issued by BPCL, cancelling the candidature of the appellant. Paragraph. Learned counsel for the appellant urged that petitioner's land did satisfy all the criteria and was in fact located between Narayan Chandrahata and Sonapal Shakal. Full stop. He also invited the court to examine the map in question, which according to him would bear out his submission. Paragraph. In the present case, BPCL had to necessarily go by the reports of the revenue officials, in this case the Tahsildar, Padamba, as regards the exact location of the appellant's land. The official version of the Tahsildar was that the appellant's land did not satisfy the criteria set down by the BPCL for the purposes of a retail outlet. So, while it is true that initially 2 reports were furnished by the Tahsildar substantiating the appellant's claim, but the 3rd report stated to the contrary. Stop. Matters concerning the precise location of a piece of land, the High Court would normally defer to the view expressed by a Tahsildar, who is in charge of all the records and who is in best position to indicate what the exact location of a piece of land within his jurisdiction is. So, in other words, the learned, neither BPCL or for that matter the learned single judge would have questioned the veracity of such a report by the Tahsildar. So, in the jurisdiction, the court cannot, on issues of location of land, simply discard the report submitted by the Tahsildar upon a field verification. Paragraph. Consequently, the court is unable to find any ground made out for interference with the impugned order of the single judge, declining to interfere with the, declining to strike down the decision of BPCL in cancelling the appellant's candidature. Paragraph. The writ appeal is accordingly dismissed.
From 57.
Oh. She's accepted. She's entered appearance on behalf of the caveator, and we say a complete set of the paper book has been served upon her.
Okay. Item 57.
57. May I please your lordship. Here I have challenged the order dated 2/8/2022 passed by Honorable Single Judge Mallard. The fact of the case is that there are 2 LIC policy that stand in the name of one Rasananda Naik, who is the son of the present petitioner and the husband of the respondent number 2 Mallard. He died in a very suspicious circumstances for which a FIR was lodged under section 302 under annexure 1. The local police has investigated and submitted the final form against which the present petitioner appellant filed a protest petition, and accordingly the learned SDGM
Talcher did not accept the final form and directed for a de novo inquiry, which is still pending, my lord. No, my lord, that two LIC policy has been directed to the amount of the two LIC policy has been directed to release in favor of the widow of Rasananda Sahu, who is the accused, main accused in the criminal case under section 302, madam. That's the my case, madam.
Where is that fact mentioned before the learned single judge that he is the accused and all that?
I have filed the FIR and all the order sheet, my lord.
No, your submission before the single judge.
Yes, my lord. I have annexed the FIR there also. That was annexure.
But even at this stage, there's nothing, no clarity on, she simply named the FIR, that's it. Was a charge sheet filed?
No, my lord, the police is not filing the charge sheet.
So what is the LIC to do then?
Which means she is the murderer of her own husband and she is now claiming
You can accuse anybody of anything, sir. You have the privilege of simply saying anything. Even if a charge sheet is not filed, you can label somebody as murderer. There's no problem. We are talking from the point of view of LIC.
I have annexed the FIR as annexure 1 in the order sheet.
You're the mother-in-law.
Yes, my lord.
She's agreed to your getting 1/3, correct?
Sorry, my lord.
The mother-in-law is agreed.
Agreed. No. The daughter-in-law agreed that the mother-in-law can get 1/3.
Okay. The mother-in-law agreed that
the daughter-in-law agreed that the mother-in-law can get 1/3.
Okay.
Correct?
No, this is the opposite. The mother-in-law wants that the money be kept in a fixed deposit.
Not opposite, because you're not listening carefully. You are the mother-in-law, correct?
Yes, my lord.
Your daughter-in-law agreed that you can be given 1/3, correct or not?
Yes, my lord.
It takes so much to explain. My English has actually become very bad in Orissa. I have to apologize to all of you. I'm repeating my questions twice, thrice. Clearly, I'm not able to be understood. So it is correct. Your daughter-in-law agreed that you can be given 1/3.
Yes.
But as mother-in-law, you're saying, how can you even keep 1/3 for yourself? You have to give me everything.
No, not that. The mother-in-law wants that the money be kept in a fixed deposit.
Because mother-in-law has named the daughter-in-laws in their FIR. That's it.
And the investigation.
No charge sheet need to be filed. No charge needs to be framed. No trial has to be conducted. But label your daughter-in-law as the murderer. Simple.
Police is sitting over my lord in spite of the repeated.
For that, LIC now should wait till police finishes all its work.
My lord, times and again the learned SDGM Talcher is asking the police to submit the report. They are not submitting the report.
So all that now in this 226 you have to decide.
No, not that. I'm not on that, my lord. My only submission is that she is an accused of 302 for her own husband. And they cannot have a glance to the order passed by the SDGM Talcher at page 27, the detailed order. Order dated.
How young is the child?
Child is a minor, member.
How young, sir?
10 years.
And staying with mother?
Staying with mother. 10.
Staying with the mother?
Staying with the mother.
But mother should not get any money. Correct?
No, the money of the share of the mother will be kept in a fixed deposit till the criminal case is decided, my lord.
It's all right. The present appeal is directed against an order dated 2nd August 2022. Passed by the learned single judge. Directing that Life Insurance Corporation of India, bracket LIC, should disburse 1/3 of the insurance money on the policy taken out or on the 2 LIC policies taken out by the deceased son of the present appellant in favor of his widowed wife, 1/3 in favor of his minor son, bracket, who's staying with the mother, bracket, and 1/3 in favor of the present appellant, paragraph. The grievance of the present appellant is that since there is a police investigation underway regarding the alleged role of the daughter-in-law of the present appellant in the death of her son, the money directed to be disbursed to the daughter-in-law should be kept in the fixed deposit. Paragraph. It is seen that the FIR lodged against the daughter-in-law at the instance of the husband of the present appellant. On 6th January 2019, is still being investigated by the police. Full stop. It appears that not even a charge sheet has been filed. Full stop. In the circumstances, the impugned order of the learned single judge appears to be equitable in the facts and circumstances of the case. Full stop. No definitive conclusion could have been reached at this stage to deny the daughter-in-law even 1/3 of the benefit, considering that she has to maintain herself and the minor son living with her. Consequently, the court is not persuaded to interfere. The writ appeal is dismissed.
Similarly, the other one also.
For the reasons stated in the order dismissing writ appeal 1186 of 2022, the present writ appeal is also dismissed. Both these contempt cases list before the learned single judge in the roster bench on 5th July 2023 in view of the dismissal of writ appeals 1186 and 1187 of 2022.
Well, in writ appeal 1187, well, I have already entered appearance, so my name has not been reflected.
All right.
Item number 58.
May I please, your lordship? My lord, on behalf of Mr. Vasudev Pujari, Hinama will be filed tomorrow, my lord, allowed to file tomorrow. And the connected similar matter has been posted to 1st August 2023.
No,
68, 58.
Similar matter was posted to 1st August. It may be
All right. List on 1st August along with WA number?
WA 1206 of 2022.
1206 of 2022.
Item 44 yesterday list.
Defects be cured in the meanwhile.
Deployed.
Item 59.
May I please, your lordship? Here, your lordship, may kindly pardon me. There were 2 defects. One with regard to deficit court fee, which I have deposited today. The other defect is with regard to limitation period of 25 days. May I, with your lordship's kind permission, present the application here? Otherwise, your lordship may permit me to file it in the registry and it may come up next week. I am ready with the limitation application, 25 days delay.
All right. That limitation application will taken on board. All right.
My, I'm obliged.
That taken on board. The reason stated the.
But may I please your lordship, ma'am?
Yes.
May
yes, please.
Present this, ma'am. Obliged. Here the main grievance is the Honorable Single Judge has been pleased to travel beyond the scope of the writ petition itself. For appreciation of that point, may I draw your lordship's kind attention to page 177, the prayer in the writ application. Prayer in the writ application was, may I just place little background of the case. He is a custom miller who has to mill the rice and provide it to the corporation. Now there is a clause 2511, which I will bring your lordship's kind attention, says that if there is any loss or damage, he has to make good of it. There is a clause 23, which says there will be a policy of insurance for recovery, and if it is not done also, he has to make good the amount, because if there is any fault of the miller, the policy of insurance is not given the amount, then he has to also pay. There are two clauses. Now, he makes a prayer here. His claim was repudiated on the ground that the claim is fraudulent. As per the report of the surveyor, which has been annexed to this writ appeal, also it was there part of the record before the Honorable Single Judge. Now, he makes a prayer before this noble court at page 177, saying that the insurance should be directed to make good. Your lordship will kindly see clause C and D. He doesn't make any grievance with regard to whether he will, so far as my claim with regard to shortage is concerned, should be dispensed with or should be quashed or not. Your lordship will kindly see clause C and D. Now, the Honorable Single Judge says the writ petition involves disputed question of fact, so he should approach appropriate forum. Your lordship will kindly see page 225, and before that page 324. I'm sorry, 324 and 325. Honorable Single Judge says that this raises a disputed question of fact, so he should approach the competent forum. But while doing so, the Honorable Single Judge has been pleased to observe that we cannot recover the amount in terms of the agreement. So that is where our grievance is, my lord. So which is, my lord, contrary, because the Honorable Single Judge says we will not entertain the
And that was not his prayer also.
Exactly, much obliged to your lordship.
All right. We just say, counsel for the appellant points out that both the prayers in the writ petition filed by respondent number 1 before the Lord Single Judge concerned settling the claim of respondent number 1 against the pro forma respondent number 4 National Insurance Company Limited pursuant to a fire policy. Full stop. Neither of the prayers was directed against the present appellant. Full stop. It is pointed out that even while observing that the claim of respondent 1 against respondent 4 involved disputed questions of fact, the learned Single Judge has erroneously restrained the present appellant from proceeding to recover the amounts due to it from respondent 1.
Which flows from the agreement, ma'am.
Which flows from the milling agreement.
Much obliged.
Paragraph. Notice returnable. First August, there shall be stay of the impugned order insofar as it concerns the present appellant till the next date.
Deeply grateful, ma'am.
They're taken on board, that to be numbered. The reason stated the delay is controlled for it.
Grateful, ma'am.
Item 60.
Well, the instruction of my client is that in the meanwhile, the order of challenge is writ appeal and that has been implemented, my lord, by the state authority.
Connected contempt petition, my instruction, my lord, it has been removed.
All right. All right. The counsel for the appellant states that the impugned order has been implemented. and the present writ appeal has been rendered infructuous. It is disposed of as such. In the contempt petition, you say, in view of the order passed today in writ appeal 1250 of 2022, the present petition does not survive and is disposed of.
Much obliged.
Item 61. Item number 61. 61.
What's if in this matter some defects are there? Kindly allow 1 week time. Lordship, I'll remove the defects.
It's a 2022 matter. What's the matter about?
Lordship, even my senior is having some personal difficulties.
That happened last time itself, madam. 5th April, both these things we heard and we adjourned it for today. 1 month's time has been given for all that. Yes. Tell us what the matter is about now.
Lordship, after lunch.
Not after lunch. If you want, we can pass it over.
Pass it.
Depending on when it comes. Yes.
Pass.
Item 62.
62 covered by my lord's judgment. That
Patita Pavan.
Yes.
In view of the judgment in Patita Pavan Tadash, the present writ appeal is dismissed.
Grateful.
Item 63.
May I please, Your Lordship? On the previous occasion, Your Lordship had directed the government to examine the order of the Honorable Single Judge enclosed on Annexure 15, because in terms of that order, my case was disposed of by the order on Annexure 16.
Is covered by that judgment.
My submission before Lordship that matter has not been effectively adjudicated, because that is the main issue that has not been adjudicated, and I cannot be affected by that order which has not been properly adjudicated. My contention before the Lordship that this person who was put into service as a classical teacher on a contract basis in the year 2009, her service was regularity after putting in ceased service in the year 2015, and thereafter, while putting in service, the government under Annexure 3 made a resolution wherein it was said that government introduced common qualification for the classical teachers. That is on Annexure 3 at page 37.
Because both of you agreed before the single judge it is covered.
Yes, but Your Lordship may say that page 76, how he's covered. I am.
So you file a review if you think it's not covered.
The petition on Annexure 15.
No, if you say it is not covered, you file a review.
He's covered because the only that distinction that.
No, I'm saying if you contend you're not covered because you've agreed.
Yes.
This is consensual order, sir. By order by consent.
No, my lord, this is not a consensual order, because I wanted to address the Honorable Court on the points involved in the matters.
Were you the counsel there?
No, since the Honorable Court had already held that government counsel said.
1 minute, sir.
My lord.
This come to page.
Yes, my lord.
79.
That is stated that
1 minute. Who the name of the counsel shown there for the petitioner? That is you,
my lord. What has happened, my lord?
Then you file a review petition, sir. Then you file a review.
Your lords may kindly review scope of adjudication. All right, your lords may permit me. Your lords may permit me to.
Counsel for the appellant now states that it has been wrongly mentioned in the impugned order that it was agreed by him along with counsel for the state before the learned single judge that the matter was similar to writ petition civil (OAC number 4280 of 2016, which was disposed of on the same day, that is 17th August 2022. Stop. It must be noted here that Mr. Kuntia, learned AGA, however, maintains that the above statement made was correct. Paragraph. Counsel for the petitioner seeks leave to withdraw the present appeal with liberty to file a review petition before the learned single judge. Disposed of is withdrawn with liberty is granted.
Okay.
Item number 64. Item 64.
None appears dismissed.
65.
65. Again, I have not filed the Bhinama, even though I have filed the writ appeal on 2/11/2022.
Yes.
6 months has been passed. Yes. I undertake to file within 2 days.
It's all right.
Yes.
Same order. Despite the writ appeal having been filed on 14/11/2022 itself, and the defect of non-filing of Wakalatnama being pointed out. Till date, no Wakalatnama has been filed. Accordingly, the court is not inclined to grant any further indulgence. The writ appeal is dismissed.
Item number 66. Item 66.
I'm sorry. On item 66, there are 4 writ appeals, out of which in WA number 1434, your lordship has pleased to issue notice.
But requisites are filed late.
Yes. And on my prayer, in fact, these cases are tagged with that case. May I, Lord, just to submit that your lordship may kindly give me a short adjournment so that I will prepare a comprehensive date chart in respect to all the cases. Here the question of law involved in all these writ appeals are same. Whether the honorable single judge was justified in passing the repudiation letter, interpreting section 15, so section 45 of the amending act 2000, Insurance Act 2015, saying that since 3 years have passed, LIC cannot repudiate the claim. May I pray for a short adjournment, my lord? I will prepare a comprehensive date chart for all the cases and
Counsel for the appellant states that he will file a comprehensive note of submissions in all these writ appeals before the next date. List on. August 17th. No, we won't say anything now.
Item 67.
matter is posted to 24th July.
All right. List on 24th July.
Item 68.
I have given. The regularization of ambulance drivers, your lordship has similar matter has fixed to 10th July.
All right. Same order.
59 said.
Item 70.
70 rehabilitation 30th August.
Right.
Item number 71.
And I have challenged the judgment of honorable single judge, in which honorable single judge did not exercise the power to adjudicate the matter properly and directed me to file the fresh writ petition, my lord. My lord, the CDM made a notification inviting application for leasing out some plots, my lord, in sector 13. The brochure I have annexed, my lord, to the writ petition, that is at page 24, my lord, of the brief. The lordship kindly come to clause 20, page 25, clause 2.5. The categories of commercial cum residential plots available for allotment are as follows, my lord. Bid category plot 80 into 50 feet, that is 4,000 square feet, my lord. I am a doctor. I applied for the commercial cum residential plot for opening a clinic, and the price, my lord, has been fixed at 8,40,000, my lord. That is at appendix. Lordship can come to page 35. Payment schedule. Initial deposit 1,50,000. I applied for
this.
the
1 minute. what has been dismissed is the IA, is it?
My lord, I prayed for calling for the records of that lottery and also original records of allocation, original records for plotting of 19 plots of commercial plots, my lord, in B category. That was dismissed without calling for the record, my lord. I said I was selected in lottery.
Some other
and I wanted to pay that entire amount and even enhanced amount. I agreed. After, my lord, 7-8 years, they rejected the application saying that no plot is available, my lord. When this Honourable Court has directed one plot shall be kept reserved for the petitioner. You lordship can come to
1 minute, 1 minute. There's something wrong. You had filed an IA for
calling for the records.
What was the IA number?
IA number, my lord, I have annexed that IA number. I'm giving you that IA number, my lord. Annexure. Only 1 second, my lord. IA number
17886.
Only 1 minute. 1 second, my lord. I am giving the IA number. That is IA number 17,886 of 2022, my lord. I filed it on 19/12/2022 on the date of hearing.
See, in that petition where they've scanned, they put one wrong IA 1786.
Without any proof of document, my
lord. The petition civil
a
itself.
single only relying on that, my lord.
Yes.
My lord, 16/12/2022, the counter was filed, my lord. In the counter, paragraph 5 at page 45, my lord. You will also kindly see.
Yes.
This is the averment. That it is pertinent to mention here that as per the layout map of the sector 13, there were 11 numbers of B category residential commercial plots available for allotment in favor of the normal applicants. As against the same, 22 applications were received. In the list of 22 applicants, the name of the petitioner was at serial number 16. Lottery was conducted on 13/8/2004. Among above 22 applicants, and in the said lottery, petition could not succeed. The 11 numbers of successful applicants have been allotted with their respective plots chosen by them due to non-available plots in the said category.
So in B category, no plots are available, he says.
My plots were available. There are 19 plots. Therefore, after receiving that counter affidavit on 16/12/2022, I filed the IA on 19/12/2022, calling for the records. There are 19 plots available, and I was selected in the lottery. And in the lottery, my lord, I am taking to a loss.
The counsel for the appellant maintains that B category plots were in fact available. And it is for that reason that IA number 17886 of 2022 was filed. After receiving the counter affidavit filed by opposite party number 2 on
16/12/2022.
16/12/2022. Stop. This was, however, this IA was for information regarding the availability of plots, which according to him was wrongly rejected by the learned single judge.
But they have communicated I was selected and give the enhancement price at page 42.
Notice returnable.
At page 42, they say, inform me after 3 years of the lottery that if you pay the
14th
August.
14th August.
14th August.
Item 72.
None appears dismissed.
Item number 73.
May I submit, my lord? This is an appeal challenging the order dated 23rd December 2020.
With the red defects.
My,
Oh, somebody's already appearing for respondent number 1.
yes, ma'am.
Ah,
My lord, regarding the disciplinary proceeding has been stayed by CAT order dated 27/9/2021. In this regard, we want to file counter. 2 weeks may be granted. Counter only affidavit filed.
no. What's the prayer in the main writ petition? I don't agree. What is the main prayer?
My main prayer is, my lord, to quash the order of Superintendent of Post Office, that is dated 10/11/2021, by which they have declined to encash my 2 term deposits of the petitioner, who is the wife of the one accused of the Postal Department. That petitioner is alien to the disciplinary procedure and also to the PAD Act they have quoted. My lord, I'll draw your attention to page number 47, para 3. In this regard, it is pertinent to mention here that to adjust the loss amount sustained by the department, there is provision to confiscate the movable and immovable properties standing in the name of the offender and dependents of the offender in accordance of PAD Act 1850. My lord, there is no such provision that they can recover any loss to the Postal Department under PAD Act. May I draw your attention to page 50, my lord. Section 4, prosecution of accountants and sureties. The person or persons at the head of the office to which any public accountant belongs may proceed against any such public accountant and his sureties for any loss or defalcation in his account, as if the amount thereof were in an arrear of land revenue due to government. Apart from that, if there is any loss, my lord, the disciplinary process is going on, and the amount is not determined as per CCS rules. Imposition of penalty for recovery.
What has happened in the criminal case?
That is pending.
And disciplinary inquiry is also pending.
Yes, my lord. Investigation going on.
No. Disciplinary inquiry is going on for how many years now?
My lord, due to the CAT order, the disciplinary proceeding has been stayed, my lord.
That stay is continuing?
Yes, my lord.
Oh. You yourself got a stay of those disciplinary inquiry?
My lord, that is regarding parcels, sending parcels, and there is some problem. It is not determined, and my husband of the petitioner, he is yet to be decided he is a culprit or not. And I am a petitioner who is having money, and if at all there is some problem, they can, under CCS rules, they can recover it. I have given.
What is the value of these term deposits?
I have deposited in 2018.
How much money is there?
A value is 5 lakhs, my lord. 2,50,000, 2 accounts.
So what kind of surety? Can you give an indemnity or surety? Suppose the money is released to you?
My lord, when the petitioner husband is working, he is an active employee.
So all the more then you can give the surety or indemnity you have to give.
My lord, as petitioner, it is not necessary that he will give surety, because
it's a joint deposit, no?
Yes. No, my lord, term deposit is single account. Earlier it was joint account. Prime one is my petitioner and second name was husband.
My lord, 2 weeks time may be granted so that we file affidavit in this regard.
All right. Counsel appearing for opposite party number 1, respondent number 1, states that they would like to file an affidavit. Explain the present position. At her request, list on 31st July.
Item 74.
74 my 25th September old pension.
75.
But the present appeal,
Defects are not removed, sir.
Malad, I'll remove the defect. Your lordship may call it next week.
Just on 31st July, defects be removed in the meantime.
31st.
Item 76.
My lord,
Cured in the meanwhile. Yes.
I pray, my lord, in that this matter may be taken 1 week after Mr. Patnaik has gone to attend his wife in hospital.
All right. Transfer the appellant stated to be unwell. List on 31st July.
Item 77.
77, I am for the opposite party, my lord, contesting opposite party. I'll be appealing.
Yes.
Yes. The issue here is about recounting, which was allowed by the London Tribunal, has been modified by the Honorable Single Judge here. Difference of vote between the contestant, the return candidate and the repeated candidate is one only.
One vote.
One. That's the reason I am carefully guarding, my client is carefully guarding to keep secrecy of that one vote, and they are trying to open it up by a prayer for recounting. But the point for consideration, whether it will be, sir, should I continue or not? Should
Yes,
we taking it up after lunch?
Oh, after lunch. All right. All right. After lunch. Right.
The difference of vote between the two was one.
Right.
But I have given that calculation in my appeal memo itself, and also to assist your lordship, I have prepared a convenience compilation. Can I just hand it over to your lordship? It bears a small list of dates and retapiled account. But I have given the list of citations I will be relying upon. Lordship sees the second page of my compilation. Total votes, if Lordship sees 2090. Petitioner, the present appellant secured, the respondent secured 820. Rabina and Das, the present appellant secured 821. There was another candidate 418. Rejected votes 31, 2090. But my client was declared elected by the concerned election authorities. Election was challenged. If the lordship sees, during election, initially an application for recounting was filed before evidence that was rejected. He did not challenge that. Second application was filed after examination and cross-examination of the present appellant. During cross-examination, referring to a particular statement before the court, he filed another application to recount all the ballot papers. If your lordship sees his application. That is, but before I take a lordship, I'll request your lordship to see the election petition, whether the election petition and material facts stated therein conforms the standard set by the Honorable Supreme Court so as to support an order of recounting. That election petition in my appeal memo, lordship sees at page 47. In fact, the crucial paragraph is para 9. It starts from page 43, running page 43 of my appeal memo.
Right.
But he gives the narration of all these notifications which are not very much relevant for the purpose of your lordship's consideration. Lordship may straightway turn to page 46, para 9. Are your lordship looking at para 9?
Yes. The counting of votes.
Yes. That counting of votes was conducted on 26/2/2023. The petitioner has engaged his agents as per rules. During counting officer counted total 2090 votes, more particularly in respect of booth number 9. The votes counted in total 133 as against total polling stated by the agents and polling officer to be 132. That is, there was variation of one number of ballot vote. So essentially what he is saying is total votes polled were 132.
So your please that let's count only booth number 9.
But here he says the total polling was 132. Total counting was 133. For this purpose, recounting is not necessary. The reason being, if you can compare the ballots issued, the voter list in which the ballots are issued and the ballots counted, if there is an excess counting of ballot, that will suffice the purpose. For the purpose, disclosing the ballot papers of all the votes, it's not required. If at all he is genuine there, to say that one vote is counted excess more than the votes polled, then these 2 seats will suffice. That will end.
What vote will you exclude then?
Beg pardon?
Which vote will you exclude then?
Then the question will arise to exclude. So till that period, he has no cause of action to say that one vote is extra counted. He must first satisfy with referring to the pleadings.
No, but he has got this 133 and 132 from the counting sheet only.
That he has not said. He is saying from the agents. He is not naming
but what did the election commission say?
They have no, in fact, no plea available with them. I don't think.
No, the court should have called from the election commission the total
for their return. For their return. Yes.
The polling.
I don't.
Yes, it is there at page 98. You will also could find the tribunal's order. The polling officer says it is 133, but votes polled were 132. One excess vote was counted. Your Lordship could find it at para 2 of the Law and Subjects order, order dated 4th February 2023 at page 98 of the brief. That apart, there was a vowel variant. It was counted as per the report of the polling officer. Lordship got it.
The report of the polling officer. It's not a statement before the court. Your Lordship is asking about the statement before the court.
Polling officer is the
No. My lords are asking something else. What is the stand of the election authorities before the court? I think I have understood your Lordship correctly. That stand is not there.
Exactly what is stand. What else can
Yes. Now, for this purpose, next, my Lordship, may kindly see how vague is the pleading with regard to recounting. This is one part of the case. That in respect of booth number 9, 132 votes are polled, 133 was counted. To demonstrate this, my lord, what is the extent of pleading he is required to make? I'll satisfy your Lordship from the judgments. I'll satisfy, my lord. Now, kindly come to para 10. Whether the statements made in para 10 satisfy and confirm the standard with regard to pleading of specific material fact. No. Kindly see. During counting in counting hall, the authorities for any oblique reason and intention accepted some ballots which ought to have been declared rejected, counted in favor of the return candidate. Kindly mark the wording. He should have been very specific with reference to booth number and specific number of votes. That's what in Jitu Patnaik's case under Supreme Court 2012 4 SCC 192. Para 46, 47, 48, 49 and 50. I'll cite. What is the standard of pleading required in these types of cases? He says some ballots which ought to be declared rejected counted in favor of return candidate. Some valid votes cast in favor of the petitioner was declared rejected in spite of objection raised by the agents of the petitioner. More than 5 votes which have been stamped in the symbol of book in ballot and which was to be counted in favor of petitioner was declared rejected merely because there was some ink mark elsewhere. After counting is over, it could be learned that petitioner has got 1 vote less from the respondent 1. The election officer published the result of counting and candidates are shown to have secured the votes and total votes rejected are as follows. Kindly see. He doesn't dispute these votes. Alok Malik 820, Ravinand Das 821, Gorangacharan Das 418, votes rejected 31. He doesn't say that these 31 votes are wrongly rejected. Total rejected is 31. Now, my lord, on the basis of these pleadings, he filed a recounting application and also evidence was laid before the court. In the evidence, Lordship sees a statement is appearing from my client. That is at page. I'll satisfy the honorable single judge is also satisfied there with regard to the learned tribunal has allowed recounting on the basis of this statement. Page 95.
95.
Yes, madam. Question number 23.
Yes.
I have no objection. Let's got it, my lord. I have no objection if counting of the said result is done against through the court. I am not admitting counting of ballots, counting of result. Result is mentioned in separate sheet altogether. In a tabular form, result sheet is maintained. If that is done, I have no objection.
No, but if the total, you say it's 2089, right? And the total is 2090, we still have to account for that one extra vote.
That's right. One. But if a Lordship says, Supreme Court says, Samsudin's case, the narrow margin of votes is no ground for recounting. I have cited those as well. Kindly see. Narrow margin of vote is no ground for recounting. You'll have to make out a specific case. Meaning thereby.
No, so we take it, this election officer's report, that in booth number 9, it was 132 votes counted instead of 133.
But that can be ascertained from comparing the ballots issued and result sheet. Only if that is established, then there is a point in recounting it, opening of the ballot papers. Ascertained, that's a dispute as to counting of one extra vote. Unless it is ascertained from the result sheet and the ballots issued, then no case for recounting establishment. That has to be first established. Secondly, for Lordship sees para 10, what does he say? But kindly see the standard laid down by the Supreme Court in Jitu Patnaik's case. The judgment, your Lordship may kindly see. Identically placed pleadings were there in Jitu Patnaik's case. Matter went to the Honorable Apex Court.
No. This what the civil judge has ordered is the recounting of
entire recounting. Man. He has allowed all the ballots to be recounted, which has been modified by the Honorable Single Judge, limiting into booth number 9 and that is.
Yes, so
how is it prejudice?
How will it prejudice you?
Blood, it prejudices me saying that the pleadings are as vague as it is.
No. That's
that has been appreciated by both the courts.
I can show your Lordship what he is required to plead. He must say what is his source of information, who was the agent.
No, this election officer's report.
It's not, that is a report from the election office. He has not filed any statement before the court.
No, but are you doubting the report of the election officer?
To that extent, your Lordship may consider. But then the other part, I don't think he has a case there. Completely vague statements of facts. Total vague statements.
No.
Some votes rejected. Kindly similar. Jitu Patnaik's ratio, kindly see.
Okay.
I may be wasting your Lordship's time.
No. It's education only always.
Kindly see page 24. What does the Honorable Supreme Court say? Whether aberrations in the election petition constitute material, but with regard to rejection of the plaintiff, constitute material fact or not would depend upon the facts of each case. As stated by this court in so-and-so, no rule of universal application can be applied in finding out whether the statements of fact made in the election petition amount to material fact or not. It is therefore necessary to consider pleadings with regard to of 309. First part of para 7D of the election petition would show that the statements comprise the following facts: illegally, deliberately committed by the counting personnel while recording the counting figure in form number 20 with respect to booth number 179. 2. The total number of votes as recorded in the electoral roll with respect to booth number 179 is 1109. Whereas in 17C, certified copy deliberately, this figure has been shown wrongly 1091. On the date of polling on a plain perusal of register of voters maintained in form number 17A, it will be abundantly clear that the total number of voters who came to vote and signed 17A register is 1091, whereas in form number 17C, it has been deliberately shown as 772, making a deliberate suppression of 319 votes. Before we discuss the above pleadings further, it may be stated immediately that register of voters 17A is not available for inspection. Rule 93 of 1961 rules provide for production and inspection of election papers. Clause DD of Rule 93(1) makes a provision that packets containing register of voters in form number 17A while in the custody of district election officer or returning officer, as the case may be, shall not be opened and their contents shall not be inspected by or produced before any person or authority except under order of a competent court. Now we revert back to the pleading set out in para 7D as analyzed above. There is no aberration that election petitioner or any of his polling agent had perused the register of voters maintained in form number 17A. Basis of knowledge that the register of voters maintained in form number 17A records that 1091 voters came to the vote is not disclosed at all. Moreover, there is no pleading that 1091 voters who came to vote at booth number 179 in fact voted. There is no merit in the contents from Mr. Mukul Rohtagi that facts stated in para 17D with regard to form number 17A shall be established at the trial after form number 17A is summoned by the court. We are afraid that such a fanciful imagination of proof at the trial cannot substitute of the pleading of material fact about the total number of voters who came to vote and in fact voted in booth number 179. The averment that in form number 17C, certified copy, it has been deliberately shown 772, making a deliberate suppression of 319 votes, pleading in the election petition. There is no averment that the election petitioner or his agents challenged part 2 of form 17C before authorities. At least there are no facts pleaded concerning that. There is no pleading that there was any challenge by the election petitioner or his agents in respect of counting figure in form number 20. The only pleading is that the illegality has been deliberately committed by the counting personnel while recording the counting figure in form number 20 with respect to booth number 179. There is thus no disclosure of material fact in respect of the challenge to the correctness of form number 20 and 17C. The pleading of material fact with regard to suppression of 319 vote in para 17D is also incomplete, as it has not been disclosed as to who suppressed 319 votes, who was the counting agent present. Kindly see the language below. Who was the counting agent present on behalf of the election petitioner at the time of counting? How 319 votes were suppressed and why recounting was not demanded. Moreover, there is no express pleading as to how the result of the election has been materially affected by less counting of 319 votes. In so and so, while dealing with the requirement in an election petition as to the statement of material fact and the consequence of lack of such disclosure, this court inter alia exposited the legal position that omission of even a single material fact leads to an incomplete cause of action and statement of claim becomes bad. The other part of para 17B relating to 462 votes is based on the preceding paragraph. The preceding paragraph 7C has been already struck out by the High Court. Therefore, pleading in para 17D in respect of 462 votes do not survive as it is. In view of the above, we have no hesitation in holding that averments made in para 17D do not set out all material fact and do not afford an adequate basis for allegation made therein. The allegation in para 7D, for the reasons noted above, do not constitute cause of action for declaring election of the return candidate to be void. And then they have rejected the plaint here. The whole election petition is rejected by the Honorable Supreme Court. And this standard as laid down by the Honorable Supreme Court, if your Lordship sees the next judgment.
Yes.
Page 26, my Lord. Kindly see para 11 of this, my Lord, page 29. The margin of votes cannot be a ground to pass an order of recounting. Para 11. This court, in Ram Sevak Yadav Sonso, this court had set out the circumstances where an order for inspection of ballot papers can be ordered in the following terms. An order for inspection may not be granted as a matter of course. Having regard to the insistence upon secrecy of ballot papers, the court would be justified in granting an order for inspection provided two conditions are fulfilled. One, that the petition for setting aside an election petition contains an adequate statement of material fact on which the petitioner relies in support of his case, and the tribunal is prima facie satisfied that in order to decide dispute and do the complete justice between the parties, inspection of ballot papers is necessary. Then we have para 12.
Yes.
Para 12, 13 and 14. I will be relying upon, my Lord. In so-and-so case, the same principle has been reiterated. That was a case where the difference of votes between candidate declared elected and his nearest rival who filed an election petition was only 19 votes, and which the figure would have come down to 9 only if the postal ballots were included. Even so, this court, after referring to a number of decisions, Salisbury laws of England and so-and-so, held that without there being an adequate statement of material fact on which the allegation of irregularity or illegality in counting of votes are founded, such averments being backed by acceptable evidence, the court, trying the petition, being prima facie satisfied that order of recounting is imperatively necessary to decide the dispute, do the complete justice between the parties, and order of recounting votes cannot be passed. Thus, the settled position of law that justification for an order for examination of ballot papers and recount of votes is not to be derived from hindsight and by result of recounting of votes. On the contrary, the justification for an order of recounting of votes should be provided by material placed by an election petitioner on the threshold before an order for recounting of votes is actually made. The reason for this salutary principle is that preservation of secrecy of ballot is sacrosanct principle, which cannot be lightly and hastily broken unless there is prima facie genuine need for it. The right of a defeated candidate to assail the validity of an election result and seek recounting of votes has to be subject to basic principle that secrecy of ballot is sacrosanct in a democracy, and hence unless the affected candidate is able to challenge and substantiate in acceptable measure by means of evidence that a prima facie case of a high degree and probability existed for the recounting of votes being ordered by the election tribunal in the interest of justice, the tribunal or court should not order recounting of votes. View in the light of these principles, we find that then the ratio in this case. Now, your lordship may vis-a-vis these two judgments, kindly see, Lord, again at the cost of repetition, the material fact alleged to be stated in the election petition. What does he say? With regard to this booth number 9 and counting of votes, rejected votes, my lord, kindly say. More particular, page 47.
Yes.
More particularly in respect of booth number 9, votes counted in total 133 against total polling stated by the agents. But it doesn't say who is the agent. Do not examine such an agent before the court. And he is trying to make a roving inquiry by saying that it is one. Some votes rejected, some votes counted.
Yes,
No specific. Kindly see, man. The whole para 10 is conspicuously absent and doesn't show any pleading with regard to any specific booth.
Just come to your para 11, page 51. 57, sir. 57.
57 minutes. Yes, please. Para 11. But this is by the respondent or written statement by me.
By you. That's what.
Should I place it, man? That allegations and grounds made in para 7 to 10 of the election petition are totally false and baseless. The respondent number 1 has lawfully and duly been declared elected by the BDO cum election officer respondent number 2 following due procedure of law. While at the end of counting of votes in different booths, it is found that petitioner has got 820 votes, whereas respondent number 1 has got 821 votes, and the person of his symbol got 418 votes, and 30 were rejected votes out of total 2090 votes. On serious objection of the agents of the petitioner regarding votes of the ward number 9, votes of ward number 9, which had already kept after counting, the same was again recounted in presence of both the side agents and officials engaged there for counting. And after such recounting, again the petitioner got 820 votes and respondent got 821 numbers of votes. It is further submitted that the said recounting was done in presence of all the agents of the petitioner as well as the respondent number 1 and concerned authorities. Thereafter, respondent number 1 was duly lawfully declared elected by issuing certificate of election on 26/2/2022 and further declared as Sarpanch by notification number 862 dated 2/3/2022. Therefore, the allegation and grounds made in the aforesaid paragraph by the petitioner are totally false, baseless, and henceforth mentioned election petition is liable to be dismissed.
No, but you don't deal with para 9.
Yes. Beg pardon?
That amendment in para 9, which he made.
I say that para 9 in concerning booth number 9.
That you have not dealt with at all.
Booth number 9 I have dealt with, my lord, in my humble opinion, kindly see. On serious objection, agents of the petitioner regarding voters of ward number 9.
What number 9 is booth number 9, is it?
Oh, ward number 9.
No, booth number 9.
Booth number 9. That is both.
I think the amendment is in his election petition para 9.
Correct, my lord.
That you have not dealt with at all.
Neither 10, my lord.
Lord, we have said.
No, my point is this: if the election polling officer noted that there was 132 votes polled, whereas 133 were counted, and you're not disputing that, that itself
In
forms the
fact,
basis.
that ward number 9 is in respect of booth number 9. That clarification can be given by the state also. That ward number 9 is in respect of booth number 9. And it was recounted. That's what I've said. That clarification can be given from the state side also.
Mr. Acharya, what do you say? Why don't we get the election commission formally to tell us what the position is? That's much better.
Your Lordship knows that the election commission is not a necessary party in an election.
Not necessary. Only,
No,
only.
let me, if my learned friend has concluded, let me answer one by one.
No, I'm asking you without his concluding.
No, yes, your Lordship is correct. The polling officer, Milord, the report was called for. Your Lordship knows that the election tribunal, while dealing, exercises the power of a civil court.
Right.
He can call for the records before from any authority for the examination. Milord, I'm not going to that procedure in detail now. Your Lordship may kindly turn to the order of both the courts below. The first, the order of the election tribunal. Your Lordship may kindly peruse. My learned friend's principal contention is that material facts have not been pleaded in the election petition. That your Lordship may kindly come to page 23 of the judgment of the Honorable Single Judge. Page 23 of the judgment, impugned judgment. Lord, para 7, 9 and 10. Lord, I do not know in what language the material facts are to be pleaded. That so far Hansura GP is concerned. Lord, page 23 of the impugned judgment, brief. Page 23 of the brief and page 9 of the impugned judgment. That so far Hansura GP is concerned, there are 2,665 number of electors, voters, as are finally published voter list 2021. For polling of votes for office of Sarpanch, the Gram Panchayat was divided into 13 booths. As per scheduled program, the polling of votes was conducted. The petitioner engaged agents duly authorized as per rules. The respondent also engaged agents at different booths. Para 9 and 10 is very important for the purpose of the present case. That counting of votes was conducted on 26/2/2022. The petitioner had engaged his agent as per rules. During counting, the counting officer counted in total 2090 votes. More particularly, in respect of booth number 9, the votes counted is total 133 as against the total polling stated by the agents and the polling officer to be 132. That is, there was variation of one number of ballot votes. Lord, para 10 is also equally important. This is a material pleading. That during counting in the counting hall, because 31 are the total number of rejected votes, recounting of those ballots would not tantamount to infringement of secrecy, because that has not been counted in favor of anyone. In addition to para, apart from para 9, para 10 deals with a material pleading, which says about counting of 5 votes illegally, rejection of 5 votes illegally, which is bundled in a separate packet, this rejected vote. That during the counting in the counting hall, the authorities for any oblique reason and intention accepted some ballots which ought to be declared rejected, counted in favor of the returned candidate. Some valid votes cast in favor of the petitioner was declared rejected in spite of objection raised by the agents of the petitioner. More than 5 votes which have been stamped on the symbol book, that is my symbol, in ballot and was to be counted in favor of the petitioner was declared rejected merely because there was some ink mark elsewhere. After counting is over, it would be launched. So this is a pleading, that is the reply your Lordship just now. I am grateful to your Lordship pointed out in response to para 7 to 11. He has evasively replied.
No, if he seems to have, I don't know, just see now.
This is my pleading,
No, page 25. Page 25.
Yes. Your Lordship meant 24. Total number of votes 2090. He got, I got 820. The return candidate got 821. The third candidate got 418. Votes rejected, 31. This makes the material difference. Apart from 9, 1 vote being counted in excess, 31 is the rejected vote, out of which, I am to get 5. That has been illegally rejected. What else, I failed to understand can be a material construed as a material fielding.
No, but
it is reply to that. Your Lordship may kindly come to the reply. Both the courts below both the election tribunal and the honorable single judge, they have given a concurrent finding. Your Lordship may kindly turn to page 98 and 99.
No. Before we go there, sir.
Man.
Before we go there, his reply has been extracted by the single judge.
Yes.
Ah.
Yes. Your Lordship may, yes. That reply, yes.
Para 11, page 25, para 11. No, para 11.
I am grateful. Therefore, the above mentioned petition is liable to be dismissed in limine. That allegations and the grounds made in para 70, your Lordship just now read it, but the para 57 or 56 is reply that has been reproduced here. He doesn't deal with it.
No, but let's just read it carefully, sir. Let's read it.
Totally false and baseless. The respondent number 1 has lawfully and duly declared elected by the Videocom election officer following the procedure, while at the end of the counting of votes in different votes, it is found that the petitioner had got 820 votes, whereas the respondent number 1 had got 821 number of votes, and the portion of his symbols were so done votes, and 31 number of votes are rejected votes out of total 2090 votes. On serious objection of the agents of the petitioner regarding the votes of ward number 9, the votes of ward number 9 which had been already kept after counting, the same was again recounted in the presence of both the side agents and official engaged therefore counting, and after such recounting.
So this is why, Mr. Acharya, there are two sets of pleadings that have come now. All right.
That's correct.
He's pointing out that there was a recounting in terms of ward number 9.
Yes.
All right.
No, even if
you are talking of some booth number 9 where you say the total votes counted were 132, whereas votes polled were 133.
That will clarify the position.
So let's get the election commission to only give us statistics. That's all. They won't count. They'll merely tell us whether these facts are correct. Whether for booth number 9
by through evidence it has been adduced, Your Lordship may kindly. That is why I am reading the Lorraine Tribunal's order. Your Lordship may kindly turn to page 19. Lord, 5 witnesses. This recounting order has been passed after evaluation of the evidence and the pleadings. Your Lordship may kindly turn to page 99. Peruse the record and the evidence adduced by the petitioner and opposite party number 1. OP number 1, the present appellant, he says that I have no objection for the recounting in court. In para 23, that has been. Just a minute, let me finish. I didn't disturb you. Please, why this Sanjay?
Who is disturbing him?
Yes, Mr. So, evidence adduced by the petitioner on the basis of the pleadings and the evidence of PW1 has corroborated the affirmation in the election petition, and whose evidence is corroborated by the evidence of PWs 2 to 5. Just now he was arguing that the agent was not examined. He has been examined. But I don't know that the facts can't be distorted. You may rely on any decision regarding addition of invalid votes in favor of the OP number 1 and rejection of valid votes of the petitioner in favor of OP number 1, and that PW3 and PW number 4, who has corroborated the evidence of PW1, that is the election petitioner, 3 is the agent, 4 is the something like that. It is there in the evidence is also regarding filing of objection before the authority on the date of counting as well as after declaration of the result. The petitioner has also filed the postal receipts of sending the objection to the video, Kuzang and collector Jagatsinghpur, which has been marked as exhibits 2 and 3 respectively, and in this regard the OPs remained silent and has not adduced any evidence. Moreover, in the evidence adduced on behalf of the OP number 1, the present appellant, it is seen that he himself has admitted in para 23 of his evidence that he has no objection if the counting is again done by the court. Hence, from the pleading and the evidence adduced by the parties, this is the finding. Not that he has relied upon the pleadings alone. It's a collective appreciation of both the evidence and the pleadings contained in the election petition. I am of the considered view that the petitioner has established a prima facie case, and that it is a fit case where to arrive at the truth, recounting of ballot paper is very much necessary. He directed the recounting in respect of the entire election. The honorable single judge rather partially allowed his writ petition and directed for recounting in respect of booth number 9. Your Lordship may kindly turn to the relevant parameter.
Yes.
3 paragraphs of the judgment I will place. Your Lordship may kindly turn to para page 28. Page 28. The written candidate, the petitioner herein cross-examination, page 28. it is not a fact that the petitioner could not have won the election if the 5 number of valid votes. Lord, this is his evidence. Evidence which has been reproduced by the Honorable Single Judge in space 28. 5 number of this, there is a specific suggestion that what would be the effect if those 5 votes would be recounted. Whether it really goes to the credit of the election petitioner or not, only a recounting can establish that. Lord, Your Lordship, a valid votes which is declared rejected has been stamped on the symbol of Kolabahi, and if would have been counted in favor of the petitioner. So also the vote counted in respect of booth number 9 was 132 instead of 133, my lord. My lord, votes polled were 133, my lord, but counting has been done 132, 1 vote is there. My lord, nobody knows what would be the fate. It can be decided by a lot even. So, my lord, as valuation of number 1 of vote, I have no objection. My lord, this is very important. This is the evidence of the appellant himself. If the counting of the said result is done again through the court, my learned friend interprets that counting is counting the calculation of the result sheet, but not the counting of the ballots, inspection of the ballots. Let Your Lordship may go further below. To add to this, para 9 of the judgment, in para 9 of the election petition, which has been quoted here and above, there is a clear pleading, at least in respect of booth number 9, that the total votes polled are 132, but the votes counted appearing to be 133. Reading through the pleadings of the election petitioner in para 10 also quoted above, this court finds that there has been specific allegation on rejection of more than 5 votes involving symbol book, which is my symbol, allotted to the defeated candidate. Above 2 pleadings while also keeping in view that there is difference of votes hardly remaining 1 for the opinion of this court, if the papers involving counting of votes in respect of booth number 9 and Perus and the votes of this booth are recounted, and simultaneously there is checking of rejected votes numbering 31, keeping in view the pleas in para 10, such ballots must have been kept in a separate seal cover. That is the rule also, Millard. The different ballots are to be kept in different seals. If gone through to find the truthfulness in the allegation in the election petition in para 9 and 10, the purpose of recounting can be resolved. Millard, that is how in the concluding paragraph, Your Lordship may turn to para 15. In these circumstances, that's the Millard direction. Page 41, Your Lordship would find. In these circumstances, this court finds, even though this court is not satisfied with the direction of the election tribunal to recounting of the entire ballots, it will be appropriate if the direction is modified to the extent restricting the counting to the extent of allegations in para 9 and 10, while keeping in view that there is difference of margin of 1 vote in between the winning candidate and the defeated candidate. This court accordingly, while disapproving the direction for whole recounting by the tribunal, modifies direction dated 4th February 2023 election petition number so and so to the extent while keeping in view the ballot papers as well as the documents relating to election having been reached the office of the election tribunal, the recounting may be confined to 31 rejected votes, keeping in view the allegation in para 10 of the election petition and the allegation in para 9 of the election petition, the issue can be resolved. Lord, what is the informity in this judgment also I fail to understand. Lord, the ballot secrecy is, Millard, as much important as the wisdom of the electorate. You can't, Millard, brush aside the wishes of the people and say that material pleadings are there. Both the courts below have given concurrent finding. The learned tribunal had directed for the whole recounting, but the Honorable Single Judge modifies it, partly allows the writ petition, keeping the law enunciated, Millard, everything, all the Jitu Patnaik, all the judgments have been dealt with. Legally, Millard, Your Lordship may kindly turn to para, Your Lordship would find all those, a series of judgments were cited at the bar. Your Lordship would find para 11 to 11, 12, Jitu Patnaik has been dealt with. Your Lordship may kindly turn to page 36, Millard. That is on a different context, Millard. That's a order 7 rule 11 petition. Here is, that is not the case. Millard, in Jitu Patnaik, all the election cases, Millard, fact is different. Millard, I am citing on a judgment of this Honorable Court, a writ appeal, Millard, division bench. My Lord, Chief Justice Chauhan's judgment, Your Lordship may kindly, all the judgments have been dealt with here also. Lord, 2009 supplementary volume 1. Lord, I do not want to burden Your Lordship with a, Lord, on the plethora of Supreme Court judgments. I have 20 judgments in my side. I, Lord, do not want to. Facts are clear. Where is the necessity of relying upon a judgment? Lord, the facts are clear. Pleadings are clear. Findings of both the courts are clear. So, Lord, where is the question of relying on the judgment which are laid down in the peculiar facts and circumstances of that particular case? There is no question of any general application of a particular ratio. But in what context this Sanamahapur case was decided, that is entirely different. It doesn't pertain to recounting at that stage. It's a 711 petition. Your Lordship may kindly turn to this. Decisions I'll come little later. There are so many judgments which I am also on ready, but that is not the case. Those judgments, cited at the bar have been extensively dealt with from para 11 up to para Millard. Your Lordship would find, I think, all the judgments cited by my learned friend Mr. Dutt, they have been dealt with.
In his own compilation, Justice Chauhan's judgment is there.
Yes, that is there. All those judgments on recounting, Your Lordship knows Justice Chauhan is an authority on compiling cases.
Right.
But he has dealt with all the recounting matters.
Right.
Beginning from that is the law is settled. Nobody says that ballot is not sacrosanct. I also do agree with that concept. But the question is whether there are material pleadings or not. On the teeth of it, Your Lordship read para 910. I read it. Both the judges read it. But where is the informity? Only my learned friend can read it carefully and find out that no, there is no material pleading. By saying so, it doesn't help. But I am grateful.
All right.
Lord, kindly see para 10. My humble submission would be the election petitioner is trying to make a fishing and roving inquiry by making a statement that more than 5 votes rejected. He is not sure what is the exact number of votes rejected. Now he is trying to open up total 31 votes by using a word more than 5 votes rejected. Kindly see those evidences, my lord. The submission that was made that the polling agents were examined, my lord, kindly see it's incorrect statement of fact. The PW1 election petitioner was examined. There are 2 other witnesses. They were counting agents. They have no source of information as to the count voting at the booth. But again, the same statement before the court, more than 5.
I am really surprised. I am really surprised.
Yes. Kindly see. Kindly see, Lord Paratate. Instead of giving a remark here, let me straight with try to persuade your Lordship.
Not facts.
Yes. Kindly see, Lord Paratate. He is not in an election petition, even absence of a single material fact. That's what the Supreme Court says, my lord. And the language used in the election petition and evidence, I'll show your Lordship, my lord. Kindly see. Again, more than 5 votes rejected. Whether it confirms the standard set by the Honorable Supreme Court and in law of election, pleading in the election petition is something different other than the normal pleadings, man. In 2002 Supreme Court says that, proving of an allegation of corrupt practice even more than a criminal trial. It is just too impossible. Rather, Supreme Court says impossible to. That judgment, though I have not given in my compilation, but that is 2002. But that I'll give that judgment, my lord. But here, your lordship may kindly see. But what he says in the evidence, kindly see, my lord. Page 86.
Yes.
Page 86 of my appeal memo, kindly see, my lord. But these words, this pleading to the extent whether confirms the standard of an election petition pleading, kindly see. Apart from the above facts, para 7, this is what is evidence before the court, my lord. In the counting hall, the counting officer with oblique intention, you are making an allegation against the government officer, accepted some ballots which ought to have been declared rejected. Does it confirm to the standard of a pleading manner? He should have said with respect to the booth number and ballot, number of ballot. That's not there.
Mr. Ratha, what you can't get away from is your statement that I am agreed to.
That's right, my lord. The statement I am now explaining, my lord. The honorable single judge has not relied upon that statement.
Not a single judge.
Kindly see, my lord. And the statement is, I have agreed to recount the result. Result is not the ballot, my lord. Kindly see.
Please.
Lord, see from the rules, my lord. The rule says that.
What is recounting result?
Yes, my lord. Result, after counting is done, they note the result in a separate sheet. Yes. That is the result sheet.
Yes.
It's not the, I have not said to recount the ballots, my lord. That's what my submission would be. Kindly see, my lord, what I have said. My lord, now it is said as if I have agreed for a recounting of a ballot. It's not that. Kindly see, my lord, my statement before the court. In the cross-examination, I have said that, my lord. I have no objection. Kindly see, my lord. I have no objection.
Which is that, Parrot?
Parrot 23, my lord. Page 95.
Parrot 21.
Question number 23, page 95, my lord.
Page 95.
Right.
All right.
This is the exact cross-examination I am showing, my lord. And with reference to the rules, what's a result? What's a ballot? There is a difference between a result and ballot.
Recounting of result.
I have no objection If counting of the said result is done, it's a reply to the result is done again through the court. Result is something other than the ballot papers, man.
No, I don't know. We can't.
That's the law. That's the rules, my lord. Kindly see. Kindly see, my lord. Rule 50. Result is entered in a particular form. That is form number 8A. That's the law.
Stop recounting the result, please. Let's recount.
Yes, recounting result is done like this, my lord. The form number 8A, the respective votes are entered by the counting officer. Now they do the counting of that result, publish the election result. Now, if they want to recount that result, that seat will be recounted with regard to the total numbers of votes polled by each of the candidates, not the ballots. That's what the distinction is, my lord. Kindly see Rule 50. Obviously, my lord, I'll have to draw that distinction in view of the difficult situation I am in. That's it. The result of counting of ballots in the ballot box relating to office of Sarpanch shall be recorded in form number 8A. So I have agreed recounting of this form number 8A result sheet. You cannot distort it and say that I have agreed for recounting the ballot papers.
Which rule are you reading?
Beg pardon. Rule 50.
Rule 50.
Then but this is what the argument was advanced before the Honorable Single Judge. After referring to the rules, Honorable Single Judge obviated that part of the admission deliberately. And on that basis, no order has been passed.
Lord, this is highly objectionable. A judge will, very honorable judge of the High Court will deliberately omit. Lord, these are very objectionable sentences. I take exception to it. This is very unfair. I can't, Lord, you may ask.
Everyone in the world is unfair, of course.
Everything is there in the order. Lord, going personally and saying.
Highly similar. So with reference to Rule 50, my admission in question number 23, with reference to Rule 50.
Yes.
Then Rule 51 months. Preparing the ballot bond.
No, but where will be the counting? I don't know. The result of counting is one thing.
Yeah.
Just come to that form 8A.
Form 8A. Besides the above, can I just submit one more? Form 8A, I'm just finding it out, my lord. Yes, form number 8. Yes. Name of the candidate, number of ballot votes pooled, my lord.
So there is a question of counting here.
Yes, my lord. They total this. They count the numbers, they total the numbers, then publish the result.
Lord, only the ballots are counted. Results are not counted.
That's what.
Counting always refers to.
Then your lordship may kindly also consider from another angle. This is not on the. This is a defense. 1 second, Mr.
Are counted.
Lord, this is a defense before the court.
Number which is reflected.
1 second. 1 second. Lord, when the election petitioner has failed to prove his case, failed to plead material fact.
No. One is evidence was laid, right? You say election petitioner examined himself. 2 polling agents examined themselves.
Yes.
You were examined.
Yes.
And then
your lordship may see their evidences. What are they saying?
No. Who else was examined?
Nobody else was examined, my lord. Nobody else was examined. And they say the same thing in the court. Some ballot papers were rejected. Some ballot papers were counted. They have failed to prove their case. Weakness of the defendant cannot be a ground to make out a case for the election petitioner.
That's a very novel argument, I think. In an election petition, the witness doesn't have any response, and that too an agent who is present in the counting hall.
Please don't give a running commentary. I'll request Mr. Senior Advocate.
I've never had.
I'll request Mr. Senior Advocate not to give any running commentary. It's not good.
No. The point is,
yes.
If you see the evidences, come to page 99.
Right.
Peruse the record and the evidence adduced by the petitioner in OP number 1.
Yes.
On the basis of pleading, let me place it. Corroborated avowment in the election petition whose evidence.
Corroborated avowment. The same statement, corroboration. You may see the evidences. What have they said before the court? I given the entire thing. Kindly similar. So, specific evidence given by the election petitioner and 2 of his witnesses. Kindly similar. Lord, he says, Lord, page 73. That is his evidence. This is examination chief. para 6, my lord, that I engage my agents. He doesn't say the name. In the booth, so also the respondent number 1 engaged his agents. As per the statistics of the presiding officer and agents, total 2089 votes cast. He doesn't say in the election petition. He doesn't say this in the election petition. Cast their vote and ballots were used and counting of the votes were conducted 26 to 22 and 22. I engaged my agents during the counting and counting officer counted total 2090 vote, particularly in respect of booth number 9 as 133, whereas it is stated by the agents polling officer is 132. As vague a statement before the court, my lord. Kindly see again. In the counting hall, counting authority with oblique intention accepted some ballots which ought to be declared rejected, counted same in favor of the respondent number 1. He doesn't give the number here. Some valid votes cast in my favor were declared rejected in spite of objection raised by my agents. And apart that, more than 5 votes which have been stamped on the symbol book, which is my symbol, and the same ought to be counted in my favor, were declared rejected merely because there was some ink mark elsewhere. Lord, what is the basis of information? Who says this? More than 5 votes? What is the number of votes?
No, this is the affidavit by examination in chief.
Yes, my lord. That's what is the evidence available in the court, my lord. Then, in the cross-examination page 79, Lord, kindly see. I cannot say the name of the agents for each booth, but I can say my agent names who are Punand Malik, Mukesh Behra, who are present in ward number 13. That's not the disputed ward, my lord. Cross-examination is page 79, man. I have not submitted any document, photo clips, video regarding illegal activities in the said election, as well as I have also not submitted any document, photo clips, video regarding violation of COVID-19. I was not present at the counting hall at the time of counting, but my agent Sambit Rautray was present. I cannot say the name of other agents present in the counting.
Come to para 29.
Para 29. In booth number 5, 3 number of votes were declared invalid and 99 numbers were invalid votes. Similarly, in booth number 2, completely contrary to the election petition. In booth number 2, numbers of votes.
Two numbers of votes were invalid.
2 numbers of votes are invalid and 226 numbers were valid. I have not submitted any document regarding before this court. And that's also not the disputed booths.
No, the polling officer was not examined.
Not examined. That's why your lordship from the beginning were to clarify the whole situation. Nobody will have any problem in that. The truth will come out, my lord, on my lord's order.
It's not necessary, my lord.
Sir, trying to avoid that situation.
He has called for the report. That he can call for any document and examine.
I agree for that. The situation.
Where is the report? Look at the procedure before this. Then I have to go to the whole thing. I fail to understand. One question, let me answer. Your lordship, I will answer your lordship's query. There is a concurrent finding on appreciation. Your lordship also read. I may not repeat the whole evidence. There is material pleading. It can't be disputed. 2 courts, my lord, the election tribunal and the honorable singles, thus they have quoted, my lord, in my lord, very, I should not say express words, they have quoted here and there. Your lordship have already read it. This solitary question for your lordship's consideration in a latest patent appeal, whether the recounting was justified on the basis of the materials. Neither the election commission nor the polling officer is a necessary party in an election petition. Your lordship knows it is a settled law. I'm not going to.
No, we are not on party, sir. Let me just clarify what is happening here.
Says that I called for the report from the polling officer.
Where does it say? Where does it say? No, where does it say? Where does it say?
No, here it says, Milord, I read it. Milord, your lordship may kindly the polling officer impugned the order of the court below. Milord, I read it somewhere. It was counted as 133 instead of 132 as per the report of the polling officer.
No, this is your Where are you reading, sir?
Milord, I am reading page 98.
Uh-huh.
Lordship got it. It was counted as 133. Milord, that is also is the admission by the opposite party number 1, the present appellant.
No. Just Mr. Acharya, 1 minute. Mr. Acharya, what he's reproducing here is your pleading.
Yes. No, Lordship is correct. I am not going to. But he himself also.
The tribunal, no, Mr. Acharya, the tribunal did not call for a report from the polling officer. The tribunal simply called for the report from the polling officer.
Milord, there is a pleading. Milord, how it can be unraveled? It can only be raveled. Milord, how is it prejudiced? If it is 131, it's 133, Milord, and 132.
No, is that factually correct or not? We don't know, sir.
My lord?
Whether that is factually correct or not, we do not know.
No, Milord, that is a pleading. The court
mere pleading is not proof, sir. No, mere pleading is not proof.
Milord, who will establish that? Unless it is opened, who will establish? Milord,
so the polling officer, some official record. No, Mr. Acharya, there has to be some official record.
No, Milord, there is an admission by the other side. That is very important.
No. There's no admission. He has denied the averments in para 7 to 10.
He says, Milord, Your Lordship, he says, Your Lordship, kindly, it is here. I read it, Milord, page 28. He says it is 132, that he admits, Milord, that allegation.
No, he doesn't say that, sir.
Let me read it, Milord.
All right.
It is not a fact that the petitioner could have been won the election if the 5 number of valid votes which has declared rejected, which has been stamped on the symbol of Kolabohi, and if it would have been counted in favor of the petitioner. So also the vote counted in respect of booth number 9 was 132 instead of 133 as valuation of 1 number of vote. He says so. It is the statement of the other side.
1 minute. Where are you reading, sir?
Milord, page 28. Milord, his reply also. He says that it was recounted. Your Lordship read his reply that it was 132.
Not a fact.
It was rejected.
It's not a fact.
Not a fact, sir.
Mr. Acharya, try to understand this.
It is not a fact, he starts.
It's a suggestion.
Try to understand, not a fact.
He's denying the suggestion.
No, that's true. But Milord, Your Lordship may kindly appreciate whether it is 132 or 133, Milord.
No, whether that itself is correct or not, how do you know?
Election tribunal. What is the role of an election tribunal then?
Why are you now I'm surprised. Why are you resenting the affidavit being called from the polling officer?
No, I am not resenting, Milord. That is not the question. Affidavit being called for the polling officer is a subsequent, whether he would be examined or not, that is up to him. Let him cite him as a witness.
Not the point here at all.
No. Suppose the court. Mr. Acharya, suppose the court wants to be satisfied that the official record reflects that in booth number 9, 133 votes were polled, but only 132 was counted. Suppose you get a formal report of the polling officer.
No, Lord, he says na Form 8A, he refers. Lord, Form 8A, Your Lordship read
Section 37. Section 37.
8A is the overall result, sir. We are now on booth number 9. We are on booth 9, where you say 133 votes were polled and only 132 were counted.
Your Lordship may kindly appreciate this point. Your Lordship may kindly
see Section 37, my Lord. Kindly see Section 37.
Your Lordship may
kindly see. The court has the power to summon anyone. Kindly see. Section 37. The procedure before the Civil Judge Junior Division.
Milord, may I submit, Milord?
Kindly see.
Your Lordship,
but it's not that it's prohibited to summon anyone and give evidence.
That is correct. That is not the case. Let him cite him as a witness. If he wishes to disprove my case,
your election petition, not mine.
That's correct.
On you, Mr. Acharya. You were the election petitioner.
Milord, I am for the petitioner. True. The court can examine also the polling officer.
That's exactly. That's what we are saying. So if the court can examine, the court should have called for the official records.
Your Lordship may kindly appreciate. Election tribunal is hearing a election dispute. It has not been finally concluded. He has, Milord, directed for inspection of the ballot papers after the appreciation of the pleadings and the evidence available on record.
No, this is that. So the evidence on record, Mr. Acharya, it's like this. You examined yourself and 4 others, correct?
Yes, Milord.
They were your own polling agents. They were not the polling officer. So that your own agents saying that, your own agents saying that, the votes counted was 132, whereas votes polled was 133 is neither
That is
here
on
nor there.
one aspect, Milord. That is one. Your Lordship, may I concede to here, Milord. Let us go by that. Milord, what about para 10 then? If 5 votes materially would affect the results of the election, Milord.
No, again, for that 5 is simply you've just picked out 5. When you're cross-examined, you say, I have no document to support this.
Milord, how can I have a document? The votes are rejected.
No,
Milord,
why only
rejected
5 are
votes.
wrongly rejected? See, 31 ballots were rejected, right?
Milord, 31 ballots are rejected. Nobody disputes this also. That is the second limb of argument. Milord,
No. But that out of that, 5 of your votes were wrongly rejected. How do you know? And why
That
5?
is the question. That is only can be ascertained after the inspection.
Ah,
That can only be ascertained after the. That is why, Milord, the tribunal. Milord, what is the duty of a tribunal then? Election tribunal has been set up, Milord, to adjudicate a dispute. It is a disputed question. That is why the specific power has been conferred upon a judicial authority to adjudicate. Milord, if the court would be satisfied after the examination of the materials produced before it, he may offend, Milord, sustain his pleas and reject my petition.
I'm surprised you're so fiercely resisting a report from the polling officer.
I'm not at all resisting, Milord. That is.
Then if you're not resisting, then please let that happen.
Your Lordship and direct, Milord, that is not the issue. I'm not resisting, Your Lordship. Perhaps I'm missing somewhere to convince Your Lordship. Milord, he is absolutely relying on certain things which are not known to election law. That is the strange part. I'm surprised. That is the thing, Milord. That is what is hunting me time and again. He is, Milord, harping on some judgments which have no bearing on the facts of the present case. Whether the polling officer's report would be called for or not, Milord, that is the choice of the election tribunal to decide at the appropriate time.
This is a continuation of those proceedings only.
My Lord?
This is a continuation of those proceedings only, because what is under challenge is the election tribunal's order, which the single judge has modified, which is now tested in appeal. So why can we not call for a report of the polling officer?
Milord, no issue. I'm not opposing to that, Milord.
That's all.
I'm not opposed to that. That's not the. I'm arguing for the.
Mr. Acharya, for the 5th time, you're saying I'm not opposing, but you're not letting the order be passed.
No, Milord, I certainly can't go into that area to prevent you.
Let us get the report of the polling officer, sir. Then you reserve all your arguments.
We are all.
Suppose the polling officer. Suppose the polling officer substantiates your plea. You should be happy.
No, that is correct. But your Lordship is passing some. I'm not, Milord, a lawyer of that area. I will prevent your Lordship to pass an order.
No, not for that. See, there must be a basis. If some official of the election commission, state election commission had been examined.
State election commission is not a necessary party, Milord.
Not for party, sir. I think you're missing the point. You're missing the point. It's not necessary for somebody to be called a witness as a witness that he should be a party.
That's the prerogative of the tribunal.
Exactly. Exactly. Nobody is talking of election commission being made a party.
That's the prerogative. That's not at this stage. It's only for the limited purpose of inspection of the ballots.
Yes.
That's correct.
All right.
Your Lordship may kindly see who are the necessary parties. Panchayat. Milord, 30, section 30, Milord.
Right, sir. Now you say one of the issues that has arisen in the election petition filed by the respondent number 1, questioning the election of the present appellate as Sarpanch of the Hansura Gram Panchayat. Which respondent number 1 lost by 1 vote. Is that in booth number 9, 133 ballots were cast, but only 132 were counted. Paragraph.
132 were polled, 33 were counted. I'm sorry, 132 polled, 133 counted.
133 were polled. Yeah, right. Sorry. 133 were polled and 132 were counted.
I'm sorry, Lord, again.
No, correct. Paragraph.
Right. Polling 132 counted. I'm sorry, Lord.
An argument to this effect was made in para 10 of the election petition and was disputed by the present appellant in his written statement. Paragraph. In the averment in para 10, reference was made to the fact that the polling officer had given a report to the above effect. However, it appears that the polling officer was himself not examined as a witness. Paragraph. The election tribunal, that is the Civil Judge Kojang,
Junior Division.
Civil Judge Junior Division Kojang, has, by the order dated fourth
January
February
2023,
ordered a total recount of all the votes polled. And this has been modified by the learned single judge by the impugned judgment dated 17th February 2023 to recount of the votes polled at booth number 9 and of recount of the 31 rejected votes. Paragraph. It must be noted here that it is also the plea of the petition of respondent number 1 in the election petition that 5 votes in favor of respondent number 1 were wrongly rejected. Stop. In his cross-examination, he is unable to state the basis on which he makes this averment. Stop. Nevertheless, these 31 votes have also asked to be recounted by the impugned order of the learned single judge. Paragraph. It must also be noted that in his cross-examination before the learned civil judge junior division, the present appellant stated, open quotation, you say 23 dot, I have no objection if the counting of the said result is done again through the court, full stop, unquote. Although Mr. P.K. Rathore, learned counsel for the appellate, argues that as per form 8 capital A appended to the Orissa Gram Panchayat's election rules 1965, it is only the single court's result, unquote, that was agreed to be recounted. It is seen that Form 8 capital A itself is titled single court's result of counting of votes, unquote. And therefore, the above statement can only mean that he was agreeable to the recounting of the votes. Full stop. Paragraph. The controversy now, therefore, is narrowed down to whether the recounting of the votes polled at booth number 9 and the 31 rejected votes as ordered by the learned single judge was justified. Paragraph. under section 37 of the Orissa Gram Panchayats Act, 1964. The Civil Judge Junior Division has the powers inter alia of summoning open quotation any person whose evidence appears to him to be material, unquote. And this certainly would include an election official, whether or not such person is a party to the election petition. Full stop. In the present case, since an averment has been made in the election petition regarding the report of a polling officer, it would have lent assurance to the Civil Judge Junior Division and later to the learned single judge, if in fact there was such report was brought on record. Full stop. Paragraph. In the circumstances, the court considers it appropriate to call for an affidavit from the polling officer in respect of the election to the Hansura GP. Requiring him to produce the report.
My lord, may I say
Election officer.
election officer of the, because BDO is the election officer. Polling officer is on each poll there is a polling officer, but they are reporting to
BDO. All right. Calling upon the block development officer. Right.
Yes, BDO is the election officer.
Who was overseeing.
Who is the
election officer in respect of the
GP
elections to the office of Sarpanch of
Yes.
the Hansura GP, to file an affidavit in this court not later than 8th May 2023.
8th May.
Enclosing copy of the report of the polling officer, if any, in respect of the votes.
If 10 days time.
Polled, or votes polled and vote counted at booth number 9. Full stop. The BDO in his affidavit will also advert to the rejected votes, giving the exact number.
Yes.
You want to get the breakup of the rejected votes?
No, they will give it. Your Lordship.
With the breakup of the rejected votes as belonging to which candidates? That's the best.
Let that come.
That will
That will
resolve the
clarify
whole
the
issue.
position here itself.
What happened? Mr. Acharya is not here. You're there, sir. Anyway.
10 days time maybe.
The affidavit will be filed on or before 10th May.
10th May.
All right. Okay. The advance copies of the affidavits be served on counsel for the parties. Stop. This for further hearing on 11th May. 11th May is all right?
Yes, sir. That will clarify the position here. It will end here only. That's fine. That will do. But I request your Lordship to.
I'm sorry, another matter, in fact.
No, it's all right.
I request your Lordship
I'm
to
sorry, I
extend.
beg another matter. In fact, before Justice Mahapatra, it was about to reach. I'm sorry, Milad.
There are separate meters are ticking.
Lord, your Lordship have made it easy. Therefore, Milad, one place.
All right. All I've said,
sorry, I beg apology.
I've called for a report from for affidavit from the BDO, who's the election officer, asking him to enclose the report of the polling officer in respect of booth number 9. And also to tell us the 31 rejected votes, which vote belong to which candidate.
Milord, he can't do that.
That he cannot do probably.
He cannot do that.
He cannot.
Milord, he can't do it, I think. It will be, Milord, with great respect, Milord, I may submit. Milord, your Lordship can pass any order under 226, I don't, but it's a, Milord, your Lordship, I leave it to your Lordship. I can't comment on that, but I don't know, Milord, how far it would be. It's a specific power.
He will have to count it, madam.
Milord, it's a
31 votes, he will have to
power.
recount.
Your Lordship knows
He
that
will only
right flows from a
recount.
statute. Just a minute. This right flows from a statute from Devi with Jyoti Vasu, Devi Hostel, it's settled.
No.
I don't
So
know, Milord.
31. No. I'm saying the 31.
That is a latest patent appeal or not, Milord, I don't want to argue on that aspect now.
No. It would mean that we are allowing the 31 votes to be counted, to be told which to whom those ballots belong.
If your
Your
lordship
lordship
will
can
direct,
pass
I
that
will,
order. I can't say no, but your lordship may.
That you will have to
I
require
don't
an
know how
order
to
from your
tell
lordship
you.
to count those 31 votes and report
means
your
that
lordship.
that would be
He
done
will
by
have to
the
open it.
polling officer. It can't be done, my lord. He becomes functus officio. Once the
polling officer,
result is
video is
declared, my
there.
lord.
No, recounting means whenever a court orders recounting,
No,
it's
that's correct.
the election
That can
officer will do the
only be
recounting.
Yes, yes,
that
election
can
officer.
only-
Election officer and polling officer, two different
So
persons.
let the election
what are
officer
you
do the
doing?
recounting.
That
So
can
one
be
part,
done by the-
no, Mr.
Sir,
Acharya,
nowhere
so
in
one part
28
of the single judge's order would be implemented therefore.
Yes,
No,
yes.
your lordship may kindly appreciate. Whether the polling officer will do that exercise, he can do it. It can be done under the authority of court alone.
Nobody is
It can be
directing
done in
that.
the
That's
court.
what they are only directing it.
So let it be
Well,
done under the auspices of the subject. Beloved, why should he disbelieve the subject and say that?
All
no,
right,
he
in
can do
the
it,
presence of the court, okay.
Let him do that. Let
All
him do
right.
that.
All right.
That's correct.
You say it is
Can-
clarified that
polling officer can be
in
trusted
respect of the
by
31
your
rejected
tribunal
ballots,
officer.
Or
it
may
will be
request.
the seal cover containing those ballots will be taken to the chamber of the civil judge junior division.
Then
And
it has to be communicated to the concerned judge,
yeah,
or your lordship may direct that.
they're all in the same place, sir. The BDO Kujang, and Kujang is where
We
the
will-
judges.
we will bring the entire ballot box here.
Let
request
it
one
be
thing.
done.
May I
Beloved,
request?
let it be done under the auspices of the subject.
Let that issue with regard to 31. Your lordship are calling for a report with
How
regard
can
to that
it
booth
be
number
that
9.
the
Let that come to
polling
your lordship.
officer will not- it has
Whenever
to
your
be done in
lordship
the presence
finds
of the
that booth
tribunal.
number 9 bears that 133 on 132, your lordship will allow the entire thing and direct them. Let that wait till that report comes with
All
regard
right,
to
so that 31 can wait. All
Yes.
right. We'll do it first for this one.
Yes.
All right.
Look, there are two aspects. Your lordship is correct.
Wait.
One is 31, other is 130.
So 31, we are keeping it at abeyance right now. So let's call for a report as regards
Yes,
booth
yes.
9.
Yes.
All right.
So let the interim order continue.
All right. Interim
Great.
order to cut it.
Your lordship may fix a date then.
11th May, sir.
11th May. 11th May. Lordship is on.
All right.
Item number 78.
70 my Sartapad.
Sartapad. All right.
8
8 May.
Item 79.
79 my rehabilitation 30th August.
30th August.
Item 80.
Page 139, the impugned order. This matter has been disposed of relying upon on order passed in WPC number 1629 of 2015. As that is different matter that relates to the 2015 recruitment, and this relates to the 2013 recruitment. So for a 2013 recruitment, there is a separate resolution, and 2015 recruitment, there is a separate guideline.
All right. He said notice returnable. Can I give you back that? 5th September.
Item 81.
81, someone has appeared. This is a case where during pendency of departmental proceedings, direction has been given for regular promotion. And all these matters are lordship take to 11th May.
All right.
Item 82.
My lord, 82, I prefer adjournment. 1 week.
All right. You say list on 31st July, defects be cured in the meanwhile.
Item 83. Item number 83.
None appears dismissed.
Item number 84.
Same order.
Item number 85.
85 state.
85, in this case, my high a short adjournment because the order has been filed on a 731, read appeal number 731 of 2021.
But that has not been uploaded till date, for which I could not place the matter because if that order, I'll cover this case, my lord.
Who has passed that order?
Honorable Justice Talpatra and Justice Rath, my lord.
Oh,
Yes, sir. 28/3/2020.
all right. At the
Three.
request of counsel for the appellate list on 22nd June, 22nd.
My lord.
Item number 86.
86, 87, 88, my lord. 11th of July, my lord.
All right.
Regulation of health workers.
Right.
Item 89.
89, 90, Sartaparada, 8th May.
All right.
Item 91.
91, 11th of July, my lord.
Right.
Item 92.
In item 92, my lord, there are certain defects. I undertake to remove the defects within 1 week, my lord. Your lordship may take up the matter.
26th June, defects be cured in the meanwhile. Right.
Item 93.
92 lordship, I am appearing on behalf of Tabitha lordship, copy of the writ.
Yes, yes, I will give the copy.
Yes. Item number 93.
92 lordship keeping it. So data since 2017, my unit has been sealed, lordship.
26th June.
26.
92, 26th June.
Obliged.
Item number 93.
None appears dismissed.
Item number 94.
May I please, Your Worship. The appellant challenges order dated 3/3/2023 of Honorable Single Judge. I have given the similar order, Your Lordship. But here 3 days delay is there. For that reason, I have filed an entry. Your Lordship issue notice and
Same order.
my lord, here
When is it
delay is
coming
there.
up, sir? 11th May.
11th May, my lord.
So that's next week only. Not even next week. Next. This Thursday, in fact. Or next week. Yeah.
Item 95.
Oh, 95, may I please, lord. Here, my lord, the learned single judge, my lord, has relied upon a decision passed by another bench, my lord, and disposed of this writ application. The crux of the issue is, my lord, with regard to payment of provisional pension. Here, the respondent was involved in a trap case. A departmental proceeding was initiated, so also criminal proceeding. He was exonerated in the disciplinary proceeding, but in the criminal case, he was convicted, my lord. He has filed an appeal. Appeal is pending before this honorable court. No order of suspension of sentence has been passed. The learned single judge proceeded and relied upon a order passed by this honorable court and directed that provisional pension may be given. Our ground is, my lord, that section 7 says, my lord, that empowers the state government to withhold part of some pension, my lord.
What happened to that 3/11/22 order?
I'm sorry, my lord.
The relied on order, what has happened to that?
That is, my lord, that order is, similar order has been passed directing the state government to give provisional pension till
What have you
pendency.
done in that, sir? Have you filed
My lord, no, I was checking up the morning, my lord. No appeal has been filed till now.
Then?
We haven't challenged it till now.
Then you accepted it then?
Lordship may issue notice, at least let them appear, my lord.
No, if you have not challenged that, then why should we issue
No, I
notice of
cannot
this?
accept because I was asserting from the website, my lord. Till now, no appeal has been filed.
You call for that file and see then.
My lord, Lordship, then
At the request of counsel, the appellant list on 23rd June.
96.
May I please, my lords? My lord, the appellant has filed before this appeal against the order of the Honorable Single Judge under Annexure 1, my lord, mainly on 3 grounds, my lord. One is violation of natural justice. Number 2 is non-joinder of necessary party. Number 3 is beyond jurisdiction of the state respondent, my lord. My lord, this order of the Honorable Single Judge has passed basing upon the documents filed by the writ petitioner at page 58, my lord. At page 58. Your lordship may kind of a glance that page 58. May I read, my lord?
Yes, please.
My lord, this is a letter issued by the Chief Development Officer, cum Executive Officer to the Block Development Officer, Ghatagaon Block.
subject reinstating of ex-MBK master bookkeeper Srimati Asalata Purana in Godadarpur GPLF. Reference such and such, sat with reference to the subject cited above. I am to inform you that an inquiry was conducted by the ex-DPM along with the OLM staff on 24th May 2022, and the findings of the inquiry committee is as follows, my lord. My lord, the inquiry was made according to this letter on 24/5/2022. I have submitted the inquiry report, which was not available at the time of hearing of the writ petition, my lord. So, lordship, may kindly see the annexure 3 at page 66. I have given the neat copy of that inquiry report, which is totally different than this observation made by the DPO, my lord. Besides that, my lord, opposite party number 8 is now working against the post of master bookkeeper in Godadarpur GPLF, my lord. Without impleading her party in the writ petition, this order has been passed.
All right, you just say notice returnable.
My lord.
In this case, my activity opposite party now 7, whose order challenged by in the writ appeal matter.
Why didn't you implead the?
Because my first page 58 inquiry report were conducted by.
No, a person who's been appointed. You don't make.
I have no knowledge, beyond my knowledge, because since the disengagement, it was found illegal.
Once the writ petition was taken up for hearing in that counter, they pointed out that another person has been appointed.
My lord.
You should have filed an application to implead her.
Because I have challenged the disengagement on the basis of 50.
This is going to directly affect that person.
Because illegal disengagement is illegal. On the case of the video letter 58 and 59. Since the date of mail or the video, time and again direct the secretary and president to reinstate the present prisoner.
Right. You say notice.
The single just taken into all the fact into consideration, my lord.
Right.
And just something.
Page 15, paragraph 6.
This Sashmita Patra is the person who was working.
My lord, now she is working as the master bookkeeper in that Gram Panchayat level federation. My lord.
You say notice, he accepts notice on Mr. Manthi accepts notice for respondents. 1 to 6. He accepts for 7. Notice will issue to 8, returnable on 2nd August 2020. There should be a stay at the impugned order. Right.
Item 97.
My lord, I have filed a miscase, my lord.
There is a stay of this order. Item 97.
97, madam, 14th of September, job conducted.
All right.
Item 98.
Item number 98, your lordship, is similar with writ appeal number 658 of 2023, which has been posted to 10.
Your lordship, keep this matter on 10th August.
10th.
The writ application disposed of by this honorable single judge, keeping in view the
Writ
judgment
appeal
delivered on
disposed of?
24th. Milord,
What was disposed of by single judge?
20. Milord, annexure 4, milord. Reach, milord. Sit down. दे दीजिए.
All right. You say notice returnable. 10th of same order. He
Yes.
accepts notice for the respondent.
Here, milord, there is
along with WA 658 of 2023 on 10th August. Same interim order. There should be stay till then.
Item 99.
And also 14th of September, my lord. Job contract.
Item 100.
Item 100, my lords. I pray for a week's time to file the certified copy.
List on 2nd August, defect procured.
Item 101.
101 page 35 is the impugned order, my lord. But short point is involved, my lord, the fixation of pay that has been wrongly fixed. But what has happened that this order has been placed basing on the one order passed in the by the state administrative tribunal, and that has been implemented. For which this case has been disposed of in light of that order, and entire recovery has been passed. At the only question, my lord, he was appointed on a consolidated pay on 18/11/2005. Subsequently, he was appointed on regular basis. He was kept on probation for 2 years. He was appointed on regular basis on 18/11/2007. And while fixing his pay was fixed keeping in view the ORSP rules 2008, my lord, though he was not on service as on 1/1/2006.
No, what is that 082913?
That I am saying that on the basis of that order, this order has been passed, my lord. But that fixation is not in accordance with the ORSP rules 2008.
What will be done in that? What is
but yes, my lord, that order has been passed and that has been implemented in respect of that person.
So what is that order?
That in that case, he is also a similarly situated person.
And where is that order?
That order has not been annexed to this.
All right. Copy of the order passed by the OAT, in number 2913 of 2015 be placed in record.
My lord.
List on 31st August.
Item 102.
Money 102.
And the counter.
Many persons to minors direction earlier order. They have filed the counter. I copy of which I received just now. I pray it took time to file rejoinder.
All right. Rejoinder will be filed. Why is that before this court? All right. It stated that counter affidavit was received. When did you file counter affidavit?
They filed on 24th of April.
Where is that? A counter affidavit to the opposite parties has been handed over in court today. Rejoinder to be filed for the next date. List for the roster bench. On 22nd of
3.
My senior is on VC as requested by.
In terms of the last order, I have filed my affidavit. The government has filed affidavit on 21st April 2023. Lords may kindly see the last affidavit. And
I have not received the additional activities.
Yeah.
Copy of the-
Yes.
No, the special ITI, ITC for physically handicapped persons of Barang. That is what you have to file an affidavit on.
Yes.
You filed that?
21st April. additional affidavit. This is pursuant to the last order dated 22nd March 2023.
This there is no decision taken by the government.
No, first two paragraphs important. Paragraph 3 and 4. And 5 is there is no decision taken by the government for construction of special ITI for physically handicapped person at Barango. Rather, government is setting up a skill upgradation center at VTC Barango instead of special ITC as claimed by the petitioner. That in view of the prayer made. This is the stand. And paragraph 3 and 4, we have also narrated the developments. Government of Orissa notified to establish a special ITI for PWDs and at Barango by notification number so and so. But the land was not suitable for setting up special ITI for PH at Barango, for which government further accorded approval for setting up integrated of one SDC and one ITI and one polytechnic in the campus of government protected land at Khudurpur, Jatani. Now the special ITI and PWD is functioning at the same place. The proceeding of the meeting and notification number is annexed to in the writ petition. That at present it has been decided that the skill upgradation center will establish at his PTC Barango campus, and in this regard administrative approval for so and so has been communicated to the executive agency.
An affidavit dated 21st April 2023 has been filed, stating that.
My lord, I am present, my lord. I am for the petitioner, my lord.
Yes, yes.
Am I audible?
Yes.
They last time they asked you to give a copy of the additional affidavit to us, but I am yet to receive the same.
All right. Copy of the affidavit dated 21st April 2023 be served upon counsel of the petitioner. List on 31st August.
Item 104.
No, the 104 for BMC, I am just filing the counter affidavit that may be taken on record. I have also served copy to the petitioner's counsel. For OP7. The Bhubaneswar Municipal Corporation has filed a counter affidavit.
My lord, I have
Today, copy thereof has been handed over to counsel of the petitioner, who needs time to examine.
the IA file has not been brought on record. 62405 I have filed, and it has not been listed.
All right, this IA 6240 of 2023. This is an application by the writ petitioners for a direction to Watco for commencement of the sewerage system in
To the sewerage.
Lakshmi Sagar.
My lord, at Bhubaneswar.
Lakshmi Sagar area of Bhubaneswar. Notice accepted by Watco. Who's for Watco?
Yes, my lord. I am appearing for the Watco.
He accepts notice. You have given him a copy of the application.
Yes, I have already received a copy. I will take
reply be
instruction.
filed within 4
I will take instruction in this regard.
This on. Give me that. PIL. No, PIL. That's it. Second August.
Item 105.
Lord, 4th of January 2023, the Lordships were pleased to grant me 8 weeks' time as a last opportunity to file counter. But I have, in fact, a big excuse. I have not been able to file it. Today, I am filing it, my lord. I pray your Lordship to accept that.
All right. Mr. Ratha hands over the counter affidavit on behalf of
opposite parties 5 and 6.
Opposite parties 5 and 6. Rejoined that
Running soft.
filed
running soft
before the next date. List on 7th August.
7th August.
Item 106.
In this matter, my lord, I filed IA for substitution of to implement the LRs of the deceased sole appellant, my lord. So the IA number 3753 of 2022, my lord, in this matter, sole appellant was the Chandra Bhadra Radu. His legal heirs being wife and daughters and son, they only pray for to be implemented as parties. Along with this petition, I filed the limitation petition also, along with another petition for that order 2209 for setting aside the abatement also. 3 IAs I filed along with this
All
petition.
3 IAs you say
So which I
allowed
only
as
pray
straight
for, can be allowed.
Yeah, allowed a straight. The amended or the consolidated memo of parties be filed within a week. What's the main matter about this? What is the main case about, sir?
P753 2022 million IA that is
No. What is the main case about?
that is arising of WA number to 10 of 2013. Arising out of single bench order mirror.
We are not asking about the number. What is the main case?
Main case in this matter, sole appellant expired after his death mirror.
Sir, your applications have all been allowed. Okay. All the 3 applications have been allowed.
High law, obligement.
Now come to the main case. Tell us what is that case about?
Mr. Arkeman, senior counsel, argued in this matter. Previously, he was arguing in this matter. I was not conducting.
So only applications you studied and came.
Not because of.
If writ appeal we ask you, only senior counsel will know.
Previously, he was arguing.
Why should we allow these applications? Even that for applications, senior counsel need not come.
I'm extremely sorry. Last time he was appearing in this matter, I was not appearing in this matter. I'm not acquainted with the matter.
You say counsel for the appellant says that he cannot argue the matter and he needs the senior counsel to argue.
I'll let it come after 1 week. Mr. Mahant will argue in this matter.
List on 18 September.
Item 107.
107 minutes. I'm praying. Well, in this case, I'm praying for an adjournment minutes. Can it be taken up tomorrow or next week? Anytime minutes.
Fresh notice to respond number 3. You are appearing for respond number 3. Who's appearing for respond number 3?
In 107, I am there for the respondents.
We are appearing for respondent. Melody is asking, are you appearing for respondent number 3? General manager, Indian man.
Yes. Lord, I am appearing for all. Lord.
Counsel to the appellant stated been some difficulty. 18 September.
Item 108.
Your Lordship, on behalf of Senior Advocate N.K. Mishra, I pray if this matter be taken up on any other day, Your Lordship.
List on 25th September. No, not 20. Sorry. 18 September.
Obliged.
At the request of counsel for the appellate list on 18 September.
Item 109.
May I please, Your Lordship? Your Lordship, just have a glance to order number 6, dated 4/1/2023. Mr. Ishwar Mohanty, learned additional standing counsel, states that he will file an affidavit incorporating the instructions received within 2 weeks. Rejoinder thereof, thereto, if any, be filed next day.
Yes, sir.
The Lordship may call this matter day after tomorrow. I will file. Day after tomorrow.
Counsel for the state requires more time to comply with the order dated 4 January 2023. The affidavit be filed positively before the next date. List on 4 July.
Item 110.
110 will, in this case, notice has been issued and that report is.
Why are they not putting tracking?
And similar matters, Your Lordship, was fixed to 25th September.
All right.
All pens.
Fresh notice returnable 25th September. Interim audit. The tracking report be placed into court.
And that there is also no limitation, my lord.
All right, we'll see next time.
Pastor matter, item number 12.
Item 12. I humbly request my lord, maybe taken up tomorrow.
Despite a passover, counsel for the
Then
appellant
maybe
is
permitted to
unable
withdraw,
to
my
assist the court in explaining how repetition against
lord. I am
private
permitted to.
parties
I'm sorry, my lord. I am permitted to
is
withdraw. the petition.
maintainable.
Permitted to withdraw, my lord.
Counsel to the petitioner then seeks
To file a better
liberty
application.
to withdraw the present petition to seek other appropriate remedies as may be available to the petition in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item number 48. Item 48.
None appears. Yes.
48, my lords.
Carry on.
To reiterate what I stated in the morning before your lordship, the honorable single judge in this case, the respondent was absent from service, unauthorized absence for 5 years. However, there was a series of writ petitions were pending in between. The inquiry had been conducted. However, that so-cause which was served on him was challenged in a writ petition wherein the university kept its commitment before the court that the inquiry has to be completed within a particular time. To that effect, inquiry, the so-cause was given. However, the honorable single judge found that that particular so-cause was not in consonance with law, since it stated the punishment within it. However, this respondent did not cooperate in the inquiry right from the beginning, prior to the first inquiry, and all through kept absent and feigned illness, etc. And thereafter, he came up in that writ application where the university gave a commitment to complete the inquiry. And that in the other writs pending, where the honorable single judge adjudicated the matter, stating that it was not properly done, it's not in consonance with law. But here, that has been challenged in this writ application to the effect that the grounds that have been challenged is that the learned single judge has not taken all the grounds stated in the counter affidavit. That apart, having held that the vice chancellor, being the disciplinary authority, cannot hold the inquiry, and that is not acceptable. That is why this writ application before the writ appeal before your lordship. And finally, the honorable single judge held that since the respondent had retired by then, so nothing remains excepting the retirement benefit to be granted to him, but with 5% interest per annum. That is what is the point of agreement, point which is the university is aggrieved with. The reason being, as I stated before your lordship, this being a state university, it would be quite next to impossible for the university to go ahead with these payments of 5% per annum. That is what is the point before your lordship to be adjudged. Your lordship, page 16, page 34, running page 34, the judgment of the honorable single judge, the final portion. Your lordship may kindly come to the 1, 2, 3, 4, 5, 6, 7. 7th line. Did your lordship get it?
Yes.
Annexure 1 is the judgment, running page.
Permissions granted. You please go ahead. All permissions granted, sir. You please continue with your arguments.
Miles. In the circumstances, this court, while setting aside the so-cause at Annexure 1 and the inquiry report enclosed, allows the writ petition. It is at this stage, considering
that the proceedings was initiated in the year 2000 and the petitioner was aged at about 46 years old in the year 2000, having attained the age of superannuation long since. There is also no possibility in continuing with such inquiry. There is also no possibility of punishment, considering that the petitioner is already attained the age of superannuation. In the circumstances, while setting aside the so-called notice by Annexure 1 and declaring the inquiry report as bad in law, this court directs the Utkal University to consider the case of the petitioner for retirement benefit of the petitioner on superannuation, if not cleared, be calculated and paid in favor of the petitioner by undertaking the entire exercise within a period of 1.5 months from the date of communication of an authenticated copy of this order by the petitioner. The petitioner will also be entitled to the interest at the rate of 5% per annum all through. This is what I emphasize here for your Lordship's consideration, which I had placed before your Lordship, that this being a state university, it sustains on the grant given by the government. So the authorities of the university, in order to spend a pie on the official stationery, also have to get the concurrence of the state government.
Yes. What else, sir? In Writ Appeal 1025 of 2021. So this appeal is directed against a judgment 17 September 2021, passed by the single judge, allowing OGC number 10148 of 2000, filed by the respondent. Questioning a show cause notice issued to him by the appellant university. And also quashed the inquiry held subsequent thereto. Paragraph. The aforementioned writ petition was the second round of litigation before this court. The respondent was working as assistant director in the Population Research Center attached to the appellant university. Initially, a charge sheet was drawn up in disciplinary proceedings initiated against respondent, in response to which he denied all the allegations therein. Stop. The Vice Chancellor of the appellant university then appointed the Joint Director of Health, Family Welfare, Government of Orissa, as the inquiry officer, and one Shri and the Deputy Director of the Population Research Center as the marshalling officer. Stop. According to the appellant, while he was expecting the regular inquiry process to proceed in a paper publication, the Vice Chancellor and Registrar of the appellant university asked the respondent to show cause why he should not be dismissed or removed from service. Stop. This led to the respondent filing OGC number 5138 of 2000, challenging the said show cause notice, in which an interim order was passed that no coercive action would be taken against the respondent till disposal of the said writ petition. Paragraph. OGC number 5138 of 2000 came to be disposed of by the single judge, recording the statement of counsel appearing for the appellants herein that the inquiry would be concluded within a period of 2 months. As it transpired, after disposal of the OJC number 5138 of 2000, respondent was asked to appear before the Vice Chancellor to participate in an oral inquiry proceeding. Full stop. This led to the appellant filing a second writ petition being OJC number 10148 of 2000, again challenging the same show cause notice. And the proceedings consequent thereto. It was argued that the inquiry itself was a sham since the outcome was pre-decided, as indicated in para 3 of the show cause notice, which read as under. Take from page 27, the quoted portion. While agreeing with the above contention, the learned single judge also agreed with the plea of the respondent that the inquiry was conducted by the VC himself, who actually was the disciplinary authority. So he not only he ended up becoming both the inquiring officer as well as the marking officer, which was obviously not permissible in the eye of law. Paragraph. Having found the entire proceeding to be without legal basis, the learned single judge set aside the show cause notice and the inquiry report and allowed the writ petition. Full stop. Paragraph. The learned single judge noted that the respondent had already long crossed the age of superannuation, and therefore there was no purpose to be served in requiring the inquiry to be undertaken afresh. Full stop. Only question was of granting him the retirement benefits. Full stop. This exercise of calculating his retirement benefits was asked to be completed within 1.5 days, 1.5 months, and the amount to be paid with simple interest at 5% per annum. Paragraph. Counsel for the appellant is aggrieved to the extent that the learned single judge has asked the retirement benefits to be paid with simple interest at 5% per annum. Paragraph. It is seen that the respondent had to face litigation from his 46th year, from age 46, and the litigation never came to an end, even while he crossed the age of superannuation. So the entire proceeding was a sham, as is evident from the proceedings narrated herein before. Full stop. The learned single judge was justified in not only setting aside the show cause notice and the inquiry report, but ordering that the retirement benefits should now be paid to the respondent. Given the amount of suffering that the respondent has had to endure, the court does not find the direction that he should be paid the retirement benefit with 5% simple interest to be unreasonable and calling for interference. Consequently, the writ appeal is dismissed. In 1026,
1026, in fact, 1025 was the main matter. This is an allied matter where the leave was rescinded, and the Honorable Single Judge held that was not in consonance with law because he should have been given an opportunity. But the question that I would place for your Lordship's consideration is the employer, having taken into account the conduct of the respondent number one, had gone ahead with such action of rescinding the leave. That your Lordship may kindly take into consideration.
Yes. The challenge in this present petition, a present appeal by the Utkal University, is to an order dated 17 September 2021, passed by the Learned Single Judge, disposing of OGC number 10814 of 2000, filed by the respondent. Questioning the cancellation of his leave by the university. Which had been granted to him 3 years earlier. Paragraph. The explanation offered by the appellate university before the Learned Single Judge was that it was done under an order of the Chancellor on the basis of a report submitted by appellant, by respondent number 3.
Herein, I would like to bring to your kind notice of your Lordships that the Honorable Single Judge having held about Dr. Huttar, because that particular project.
No, that's anyway. We're not going to all that. The Learned Single Judge has interfered with the impugned order, since it was adverse, it had adverse civil consequences to the respondent number 1, but was passed without compliance with the principles of natural justice. Full stop. Having heard learned counsel the appellant, the court finds that no error has been committed by the Learned Single Judge in quashing the said order. Indeed, it was issued without compliance with the principles of natural justice. No grounds have been made out for interference. The writ appeal is dismissed.
Pastor matter item 61.
My lord, I am sorry, my lord, the annexures are not properly page marked, my lord. There are some defects, my lord, in the report. Only if your lordship allow 1 week time, my lord, I will remove all the defects, my lord. Even not page mark.
Granted you a month's time, sir. You'll carry on with the matter now.
Yes, my lord.
Yeah.
My lord, I have challenged the order of the Honorable Single Judge, my lord, because the findings of the Honorable Single Judge are contrary to each other, my lord. Your lordship may kindly see paragraph 15 of the order, judgment, my lord. As page 28, my lord.
His lordship has held that it is well settled by law that the employees, after having been held guilty of unauthorized absence from duty, cannot claim the benefit and during the period of unauthorized absence. And the next paragraph, my lord, his lordship has held that the continuous absence of the petitioner for such a long time cannot entitle him the pensionary benefit. But the rule says the reverse, my lord. Rule 72 says that, my lord, unless he is removed from the service, he is entitled, my lord. And he has also rendered the service for more than 10 years, my lord. The fact is that the petitioner is appointed as a primary school teacher, my lord, on 12/10/1974, my lord. And he continuously served for 10 years till 14/11/1984, my lord. Thereafter, he remained absent, my lord, due to illness.
This review petition was dismissed, correct?
Yes. No, review petition was allowed, my lord.
Oh, I see. All right.
And another
Review petition was filed by whom?
Filed by the present appellant, my lord, as petitioner, my lord. And the government filed the petition to recall that order. That was not considered in this judgment, my lord.
I'm not able to understand, sir. Are you really saying the review petition was allowed?
Review petition was allowed by the Law and Administrative Tribunal, my lord. And
sir, what you have challenged here is an order passed with a single judge.
Yes, my lord.
In a review petition. Please come to Annexure 1, sir.
My lord.
Annexure 1 is what?
Annexure 1 is judgment, my lord.
In what? In a review petition, correct?
Yes, my lord.
This review petition at Annexure 1
my lord,
was filed by you.
Yes, my lord.
It was allowed.
Allowed, my lord. Your lordship may kindly say Annexure 5.
But I'm asking about Annexure 1. Why are you going to Annexure 5?
My review petition filed before the...
This Annexure 1, don't talk about some other annexure. This Annexure 1, which you have, is a review petition filed by you.
My lord.
It was allowed.
Dismissed, my lord.
But after 4 times asking you, you're saying it is dismissed.
My lord.
Till now it was allowed.
It was dismissed, but a review petition filed by me before the administrative
tribunal can come later. So a review petition filed by you was dismissed.
My lord, dismissed by the Honorable Single Judge, my lord.
Very good. So first question, answer.
My lord.
What were you seeking review of?
Review of the order filed by the Honorable...
order filed?
Order passed by the Administrative Tribunal, my lord.
Okay. When?
That was in 2016, my lord.
Did you challenge that order?
I filed a review petition challenging that order. And my review petition was allowed there, my lord, by the Administrative Tribunal. And the government filed a petition to recall that order. Then the case was transferred to this Honorable Court, my lord.
So the review petition was filed by the government?
No, review petition was filed by me. Recall petition was filed by the government.
So the review petition filed by you before the tribunal was allowed by the tribunal?
Yes, my lord. Okay. Then the government filed the petition to recall that order. That was heard by the Honorable Single Judge. But my review petition was rejected, my
lord. Sir, I don't know. I think both of us are beyond understanding. You should pardon us, sir.
Your lordship may kindly say Annexure 5.
Sir, this order that has been passed at Annexure 1 is a recall application by the government.
By the government.
You kept telling us this Annexure 1 is a review petition filed by you.
Sorry, my lord. Perhaps I am unable to convince your lordships.
Yeah, actually, we have to deeply apologize to you. What you are saying is beyond our comprehension.
No, my lord.
Completely beyond our comprehension. Every time we ask you a question, you say yes, and then it comes out something else.
Let me go chronological, my lord.
No. You come some other day when we are better. You are very clear, we are totally unclear. All right.
No, my lord.
Sorry, my lord. We apologize to you.
Sorry, my lord.
So unclear.
Sorry, my lord, if I am unable to convince your lordship,
It is our fault only.
Inadequacy of
No, it is our fault only.
No,
Your
my lord.
fault.
No, my
Yes,
lord.
yes.
If your lordship will tell like this, my lord, your lordship may pass it.
All right. Counsel for the appellant is requested to prepare a comprehensive list of dates clearly indicating how the present appeal has come to be filed. List on 14th August.
Obliged.
Pardon me, your lordship. Your lordship, just a moment.
Supplemental list, fresh admission item number 1, CRLMC 1497 of 2020.
Not pressed.
Dismissed as not pressed.
Item number 2. Item number 2, CRLMC 1605 of 2020.
None of is dismissed.
Item number 3.
Same order.
Item number 4.
May I please, your lordship? My lord, the petitioner filed this application for quashing the order under Annexure 3, issuing a NBW against the present petitioner as well as the criminal prosecution, my lord. I have prepared a short note on my lord. My lord, here the my lord, here has been lodged on 21st December 2014, registered as 498A302 34 IPC, and charge sheet filed on dated 19/4/2015 against the husband, father-in-law, mother-in-law, and the brother-in-law. The present petitioners are married sisters of the deceased, my lord. My lord, they have not yet been charge sheeted, my lord. The charge sheeted accused persons have been acquitted. Under Annexure 2, I have filed the judgment and depositions, my lord. The prosecution has not established.
The petitioners are
married sisters, sister-in-law of the deceased, my lord.
Sisters and sister-in-law, a huge difference, sir. I thought I was very dim in my understanding. There's a difference, no, between sisters and sister-in-law.
Sorry, my lord. Sister-in-law, my lord. Sister-in-law of the deceased, my lord. They have not been charge sheeted, and the charge sheeted accused persons have been acquitted under Annexure 2 I have given, and the prosecution has not established the guilty of the accused persons, the informant, the father of the deceased, brother of the deceased, and other independent witness have not supported the case of a prosecution. And my lord, kindly see, after acquittal in 2016, in 2019, the learned IO has filed an application to issue NBW against the present petitioner. Accordingly, the learned magistrate has issued NBW under Annexure 3, my lord. My lord, kindly see the judgment under Annexure 2, page 25, running page 25.
You are on a date, sir. That's all can be done.
My lord?
Where are they residing, these two? Here in Kendrapada only. One is in Kendrapada, one is in Cuttack. Where is the case going on? Cuttack.
Chaudhar police station. Cuttack.
So you appear before that court, sir?
My lord, last occasion your lordship directed to submit the up-to-date status, my lord. Charge sheet has not yet been filed. After so many years, the married sister-in-law will face difficulty, my lord.
What is your instruction?
So that in this matter was grievous in nature. Let them move with the trial.
Principal accused already accused.
Both the accused persons.
Ascertain the status. What happened?
So
they took adjournment instructions on the status of the case. So, twice adjournment were taken by you, sir.
So instruction, operative instruction are not there.
So just keep on taking adjournments. Don't comply with the order.
Yes, sir.
You have a copy of the orders passed by us, sir.
Sir. Pardon, sir.
Orders passed by this court.
Sir.
Do you have copies?
Yes, sir. Sir, no.
Just show him. Only for your benefit, please see the orders, sir. And please remember them, because you don't seem to have time to obtain copies of the orders. See the orders dated 4th January. Actually, 6th November, 2021, 4th January 2022, 12th January 2021. Are you new to the court?
Sir.
You're new to the court.
Sir.
So you do not know how orders are placed in the file. All right.
Sir, last chance.
No, please read the orders, sir. Next time I ask you, you should not be blank.
Entry bounded past call shall continue till next date. Sir, learned counsel for the state shall obtain instruction regarding status of this case in the meantime.
Then next order.
Learned counsel for the state.
Actually, take him to the 6th November order.
Yes, but the orders are there.
Please read the 6th November order. Para 2.
PK Maharaj learned additional standing counsel shall obtain the entire case diary, inform the court whether any final charge sheet has been filed or not.
Next order.
Sir, so the state council
difficulty in just reading orders of the court.
So state council obtain instructions regarding status of the case.
What is your name, sir?
Sir, my name is Samarish Jena, sir.
How long have you practiced?
Sir, 20 years. 20 years.
20 years. You practiced in the High Court or?
There, my lord, on the last 3 occasions, we have sought time to take instruction. As last chance, lordship may kindly give.
All right. Counsel for the state wants last chance to obtain instructions. Interim order to continue. List before the roster bench. On 7th August.
Item number 5.
I will raise before points before the learning court will.
All right. Permitting the
Item number 6.
6, your lordships. It's a case under the 13.2 and 13.1 CD of the Prevention of Corruptions Act. My lords, I have challenged the order of cognizance. Allegation of misappropriation of money in a plantation program, my lords. The assistant soil conservating officer, in connivance with another officer, has misappropriated the amount. For their mistake, my lords, the junior officers are being entangled in this case. The junior officers, the present petitioners are junior soil conservation officers. They were not named in the FIR, your lordships, but in charge sheet, their name is, they have been added as an accused persons.
When was the charge sheet filed, sir?
Charge sheet is filed after 5 years, your lordship. On 25/11/2000, pardon your lordship, 29/9/2004, charge sheet has been submitted.
How many years ago, sir?
After 5 years of.
How many years ago?
It is 17 years ago.
17. My arithmetic is very poor. No, yours is poorer.
Third. Well, let's.
Which year are we in?
Pardon?
Which year are we in?
It's 2023.
2023 minus 2004. How many years?
19 years, your lordship. Pardon, lordship.
Good. Thank God. I thought my arithmetic was very poor. So 19 years, nothing has happened in your case.
No, your lordship.
And you're still arguing. Should we allow something to happen after 19 years? We should, no?
As your lordship,
no stay was granted. You went and told that vigilance court and his counterpart also would oblige that court. They'll say matter is pending in the High Court. Nobody will do anything. No? Whether stay granted or not.
No.
This is how things are functioning, sir, in this state. No stay is granted by us. But the trial would not have moved an inch. You want me to discuss all this and dismiss, or?
As your lordship pleases, I will raise all the points.
The petitioner to raise all, please. at the appropriate stage.
A sincere apology, your lordship.
Not at least you should sharpen your arithmetic now.
My lord, I mistakenly I said that.
All right.
Item number 7.
May I please, your lordship, challenging the order of cognizance.
Yes.
Allegation is the petitioner one dashed his bike with the informant, and thereafter there was some quarrel between them. Then the petitioner, along with other petitioner, came to the house of the informant. They assaulted the informant and his family members. And later on, 307 are mechanically added.
All right. Permitting the petitioner to resolve, please. The interim order is vacated.
Item number 8.
Well, the present cognizance and complaint, it was quashed by this honorable court, page 40. So in the 482 CRPC concerning the 3 SCST Act, my lord. But after it is the event of 2017. So when it was quashed, Annexure 7, a complaint was filed after my lord 6 years, and cognizance is taken, page 47 by the special court.
The SCST Act.
SCST Act. So but it was
all these, please, you can raise, permitting the petitioner to raise all, please, at the appropriate stage.
Item 9.
My lord, I am appearing for. Pardon, my lord. My lord, I am appearing for the operator number 2. I have already filed the Vakalatnama. Receipt is here, my lord.
None appears dismissed.
Item number 10.
None appears dismissed.
Item 11.
Same order.
Item 12.
12 mail permit to withdraw mail.
Dismisses withdraw.
Obliged.
Item 13.
None appears dismissed.
Item number 14.
Raised before the court below.
Permitting the petition.
Item 15.
Item 15, may I praise the lordship. The charge sheet has been filed for all alleged offence under section 363, 365, and 368 of IPC. Well, file an application for discharge, allow all the peace before.
Permitting the petitioner to resolve these. All right.
Item 16.
16, madam, permitted to raise all the point at time.
Correct.
Item 17.
None appears dismissed.
Item number 18.
May I please, your lordship. The face notice may kindly be issued because they have a glance to the annexure 1 will have. They will be challenging the criminal proceeding under section 12 of PWDV Act, my lord. So notice sent twice to the opposite party. In one case, he is appeared, that is annexure 4, my lord. That is the appears in RPFM number 167 of 2019. But he has not received that summon. The opposite party.
He may not appear before the court below then.
My lord?
Makes your. He may not appear before the court below. That makes your plea.
He sent notice to the petitioner. That is annexure 1, my lord.
All right. What's the plea on which you are seeking quashing?
Quashing because after 4 years he filed a domestic violence case against me. He voluntarily left my house. So subsequently he has not filed in the year of 2016. And subsequently, after 4 years, he filed a domestic violence case. So notice sent to the, after admission, notice sent to the person concerned.
No, he or she. I think it is she who has filed.
See. The opposite party's wife.
He includes she.
Sorry, violence.
No. General Causes Act says
sorry, violence.
You're not wrong.
Yes.
So there are 2 petitioners.
There are 2 petitioners.
The second petitioner is 90 years.
Second petitioner, he has already been dead.
Then what are you doing? You're not amending the cause title, nothing.
I came to know that because the year of 2020, Millard, this case, year of 20.
Then
to know that this Ramanath Mahanti is dead.
Then.
So I send the cause title, Millard.
Just like that. Because I asked you, you have to change now. You don't have to do anything.
Because
did he die, sir?
It has not been listed, so.
That's what. In fact, I apologize to some counsel today also. Our mistake of listing all this. We should not list all these
Press
parties.
notice may kindly be sent to the.
No, you don't have to do anything. We have to keep issuing notice.
Because it has not been, because we submitted the requisites to send the notice to the opposite party, but he has not been in that. That has been issued a fresh opposite party return to unserved. Endorsement address not known.
It's all right. You can take all these pleas at the appropriate stage. Permitting the petitioner raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item 19.
None appears dismissed.
Item number 20.
Gentlemen, I may be permitted to raise all these, please.
All right. Permitting the petition.
Item 21.
None appears dismissed.
Item 22.
Same order.
Item number 23.
I may be permitted to raise the point.
Correct.
24.
None appears dismissed.
25.
Same order.
Item 26.
Same order.
27.
Yes.
My lord, in-laws and the husband have filed this application for quashing of the proceeding. Your lordship will kindly.
No, address is insufficient. That's the remark.
That is the address given in the family court, my lord. There is a mutual divorce, my lord. After that divorce, my lord, which he has given in the cost title, my lord, I have reflected that.
Divorce is mutual consent or contest?
Mutual consent, my lord. Both the petition, I have annexed that.
Then you should get her affidavit.
Pardon, my lord?
Then you should get her affidavit. Something you have to do.
After taking rupees 1 lakh, my lord.
Where is that decree of divorce?
My lord, that is decree of divorce, my lord. That is a page. Your lordship will kindly see.
You'll have to do something to find out. Why don't you ask the IIC?
Annexure 4, page 29, my
you say the notice to respond number 2, opposite party number 2 has been returned with the remarks. Insufficient address.
Yes,
the IIC of the concerned police station will ascertain the correct address and will be furnished to the registry within 2 weeks thereafter. Fresh notice returnable before the roster bench on 22nd August. Interim order to continue. All right.
Item 28.
None appears dismissed.
29.
No instructions. 29, no instructions.
No instructions dismissed.
Item 30.
None appears dismissed.
Item number 31.
May please your lordship. For quashing of FIR, lordship, the petitioner is the advocate of the co-accused persons. The co-accused persons and the informants are from common ancestors. There is a dispute. There are several civil disputes of between the informant and co-accused person. Petitioner is the advocate of the co-accused person. That's why he was falsely implicated in this case.
No, but what happened? Notice was issued long ago. Notice served or not? Requisites not filed. Has been filed but kept here in. Why is requisites not tomorrow? All right, the requisites file be utilized for the fresh notice. There's an IA for impleading. IA 47, IA 47 of 2020. For the reason stated, the applications are allowed. Informant is treated as opposite party number 2. The consolidated cost will be filed with it. To be. And the main matter, you say fresh notice returnable before the roster bench on 9th August. Interim order to cut.
Public. Item 32.
None appears dismissed.
Item 33.
None appears dismissed.
Item number 34,
Same order.
35,
Same order.
No instructions, my lord.
No instructions dismissed.
item 36,
May I please, your lordship? In this case, the petitioner accepts the input order of High Annexure 5 as 37.
No such person in the addressed.
Beg pardon? Notice has issued, but that is unserved in 2 occasions.
No such person, it says.
So initially,
This is what, 138?
Again?
No, PVW.
Domestic Violence Act. In other 2 cases, the wife has appeared and maternal offense.
Which other 2 cases? Which other 2 cases?
I have given Martha number 41 by 15 and 144 by 19. In one case, I have prepared an appeal, and another case he has prepared appeal. Both cases are under hearing.
This is 2,000 for house rent. That you and 3,000 monetary relief. This is all you're challenging.
So, wife has been divorce has taken by divorce is granted by the wife. A divorce granted family court, and thereafter the wife filed a DB case before the SDGM Bhubaneswar.
All right.
My submission is that whenever there is no relationship wife and husband, how the DB case is maintained. That ground, once again, I came to the Honorable High Court has said directed to raise all the points before the SDGM, but SDGM could not consider the said point and again allow the section 19 and 20 of the DB granting the maintenance and the house rent. Wife, there was a marriage, and after marriage, 1 month she left the house in 1/8/2011, and thereafter wife filed a divorce case against the husband, and that was allowed by the family court on 22nd 9/14, and thereafter the wife filed a domestic violence case against the husband.
But now, how are you going to serve the wife now?
No, she is working.
Where? It says no such person in this address.
I'm allowed. Take correct address.
Notice to the respondent, opposite party has been returned with the remarks, no such person in this address. The petitioner will ascertain the correct present address of the opposite party and furnish to the registry within 4 weeks. Thereafter, fresh notice returnable before the roster bench on 4th September. Interim order to continue.
Okay. Item 38.
None appears.
39.
My lord, permitted to raise the points.
Right. Permitting the petition based on this.
Item number 40.
Item 40, Your Lordship, and for the wife. Your Lordship, I filed a maintenance application in 2020, which is in page number 10, Your Lordship. And since 2020, Your Lordship, no order has been passed by SDGM Titlagarh. So if Your Lordship may kindly direct the SDGM, learned SDGM Titlagarh.
A report be called for from the SDGM Titlagarh
To dispose of the case at
No,
the earliest.
on the current status of CMC number 9 of 2020 stated to be pending in his court. List before the roster bench on 4th July.
Obliged, Your Lordship.
Item 41.
None appears.
42.
Same order.
Item 43.
On behalf of Ms. Chandana Misra, item 43 and 44, I pray for next week. She is suffering from COVID, my lords.
All right. Concede for the petitioners stated to be unwell. List before the roster bench on 9th August.
Deeply obliged.
Item 45.
May it please, Your Lordship. Your Lordship, here the petitioner is a victim, Your Lordship. She lodged a complaint against the accused person under section 376(2)(n) and the POCSO Act and the SC/ST Act also there, Your Lordship. My Lord, may kindly peruse page number 88. That is the impugn order, my Lord, in this CRLMC application. Beg pardon, page number 91, Your Lordship. What happened, my Lord?
the accused filed a criminal appeal before this honorable court, Your Lordship. During pendency of this criminal appeal, he filed another bail application before the learned court below, Your Lordship. And without issuing notice, the bail granted to the opposite party number 2 in this case, the accused, Your Lordship.
All right, you say notice returnable. 5th July for the first bench. In the meanwhile, okay, just say that. That's it.
Item 46.
Your Lordship, may I say
challenge
one thing?
1 minute. What are you challenging in this petition?
My Lord, I'm challenging the order granted by the learned court below, Your Lordship.
Let the juvenile has been granted with the bail, my lord. A juvenile has been granted with bail, my lord. That is a challenge, my lord. So, Lordship, may kindly see page 91.
So why don't you apply for cancellation of bail?
My Lord.
Why did you
These
apply-
children, no more juvenile.
Oh.
Lord, on the date of occurrence, my lord, he was 17 years old, my lord. Therefore,
Just see your prayer clause.
My Lord. Was the impugn order dated 14/10/2020 passed. Yes, I'm considering prayer only. Causing the impugn order dated 14/10/2020 passed in criminal appeal number 29 of 2020 by the learned first additional session judge.
It's called a bail appeal, is it?
My Lord.
Criminal appeal is actually bail appeals.
My Lord. Your Lordship, already one appeal bail application pending before this honorable court, Your Lordship.
No, this bail appeal was filed by him, is it?
Beg pardon, Your Lordship.
The bail appeal was filed by the
accused, Your Lordship.
accused.
My Lord. He already preferred a bail application before this honorable court, my Lord. And that bail application is pending. During that time, he filed another bail application.
What is that bail application number?
CRLA number 348 of 2021, my Lord.
Which is pending in this court.
Yes, Your Lordship. Well, thereafter, after that, he withdrew that bail application, my Lord. After release from jail, he withdrew that bail application.
Okay, and right now, is anything pending in this court?
No, my Lord. But, my Lord, after release from that case, Your Lordship, he withdrew this application. Your Lordship may kindly call for the criminal appeal number 348 of 2021.
All right, you see. Why can't you? There's no provision for cancellation of bail, is it?
My lord. Yes, would have filed, man.
Isn't there a provision for cancellation of bail?
My Lord, he preferred under Juvenile Act.
No. Bail granted to him. Suppose he's violating the bail condition. Can you not apply for cancellation of bail?
I'm not challenging the violating the condition, Your Lordship. It is suppression of facts. And also the notice not served to the complainant, Your Lordship.
All right. We just say notice returnable. He accepts notice for the state. List along with record of, what is the record of the bail application number, sir?
CRLA number 348 of 2021.
348 of 2021. All right.
Item 46.
None appeals dismissed.
Item number 47.
Your Lordship, item number 47, same matter already pending before another bench, Your Lordship. Same related matter, Your Lordship.
Where is that?
Before Honorable Court of Sri Sasikant Misra. Same related matters, Your Lordship.
List. The defects are also there.
I will cure the defects, Your Lordship.
When is it coming up?
I have not the date, Your Lordship.
Do you know the number of that other matter?
I have not noted it.
See this on 10th July. Defects be cured in the meanwhile.
Item 48.
Please. Sir, the NBW issued against the petitioners due to the on 12/12/2022 due to all Odisha bar strike, the petition not entered into the court premises. And the petition is absolutely repeated call for not took step on his behalf. Therefore, the NBW issued against the petitioners.
What's the offense, sir?
21 NDPS Act.
I'm not inclined to interfere, sir. Not inclined to interfere. What do you wish to do? What do you wish to do? Dismiss this withdrawal. Put in the prayer clause.
Item 49.
None appears dismissed.
Item number 50.
Same.
51.
Wait, please, Your Lordship. My Lord, item number 51, here the petitioner pray for passing of the NBW, Your Lordship. May kindly have...
What the offense, sir?
My Lord, the petty offences are there. 147, 148, 294, 506, 427, 153A, and some offences.
My Lord, 436 is there, my Lord.
Not inclined.
Your Lordship, in the charge sheet also, the petitioner's
That's all right.
I'm permitted to withdraw, Your Lordship.
Dismiss this withdrawal.
Item 52.
My Lord, 52 and 53 rising out of one matter, Your Lordship. Your Lordship, here, Your Lordship may kindly peruse item number 53.
Yes.
The petitioner is an ex-MLA of Kandhwa, Your Lordship, Fulbani. A FIR registered
Yes.
under section 170, 417, 419, 384, 395 against unknown accused person, Your Lordship. Thereafter, my Lord, because of the media hype, Your Lordship, and because of the opposition parties' propaganda, the present petitioners are entangled in this matter, Your Lordship. And that also reflected in page number 51. The complainant himself said that the petitioner are not involved in this matter. Page number 51, may kindly have a glance, Your Lordship. 50 and 51.
Made the complainant a party here or not?
Yes, already met the complainant as a party to this CR.
There are defects. What is this? 52 and 53.
52 and 53, both are the accused, my Lord.
Fine. Just say list on 22nd June, defects be cured in the meanwhile.
Grateful.
Charge sheet has been filed, my Lord. Charge sheet has been.
Item 54.
My Lord. It's a matter regarding dispense under section 205. The accused petitioner is the relative one to the informant who has filed the FIR for a hand loan of 2,50,000 for some election expenditure against her wife for the corporate election. So on that basis, some what been exchanged between them. But as a informant is a advocate in practicing.
It's all right, sir. You can go. Definitely appear in the court.
Sir, already says some decisions are there in this High Court and also from the Apex Court. We can dispense with 205 physical appearance because he is engaged in a responsible job in Smart City Limited under Bhubaneswar.
No problems. He should appear. All right. Not inclined to interfere. You want to withdraw this? Dismiss this withdrawn.
Item 55.
Release of a bus, seized bus, my lord. The petitioner is the owner of the bus and the case was seized for the offense under section 20B and 25 of the NDPS Act. And 4 lady passengers were found carrying 34 kg, 850 grams of ganja. All 4 lady passengers were arrested and the bus driver, helper and cleaner. All 3 were also arrested.
What is the defect number 6 is what?
In view of the judgment.
Just now I received the copy.
You received the copy?
Yeah, just now I received.
All right. Counsel for the state says he's just now received the copy and he needs time to examine it. Let's look for the roster bench. On 15th May.
Assist Ranjan.
Yes.
Item 56.
None appears dismissed.
57.
My lord, the petitioner was earlier on bail, my lord.
Due to lawyer's hesitation at Sambalpur, the NBW was issued on 13/12/2022, my lord. That is an annexure 1, page 8, my lord. And he was on bail, that is at annexure 3, running page 16, my lord.
When were you to appear, sir?
My lord, due to strike, the petitioner was unable to appear, your lordship.
No, not inclined, sir. This is all part of that same case. What do you wish to do? Put the prayer clause.
Yes, my lord.
Withdraw? Yeah, dismiss this withdraw.
Item 58.
My lord, the case of the year 2010, my lord. Now the victim and in that year the matter was settled and they have resided separately and both were married separately and blessed with children separately, my lord. Last
Give some affidavit, sir. You have to bring an affidavit.
Yes.
Not like
notice
this.
may be issued.
No. You bring an affidavit, then we'll issue.
Two stand kind of.
Counsel for the petitioner needs some more time to produce the affidavit of opposite party number 2. Let's go for the roster bench on 11 July.
Item 59.
Interim order.
Yes.
59.
None appears dismissed.
Item number 60.
May I please lordship, my lord, I am in PC, my lord.
Yes.
Petitioner, my lord, challenges the order dated 8/8/2022, my lord.
Defects, sir.
Yes, my lord. Yes, my lord.
List on 3rd July. Defects.
Item 61.
Item 61, my lord, kindly taken up next week, my lord. In the meantime, I will remove the defect.
Same. 3rd July. Defects be removed.
Item 62.
It's not challenge the order of cognizance, my lord. Annexure 1, page 8, my lord. Your lordship will kindly see 2 cases have been filed, my lord. PS case number 113 is the counter case of PS case number 114, my lord. 114 has lost by me, my lord. What the police had done, my lord, he has not examined me in this case, nor examined my witness, and has examined the witness of other side, my lord. The opposite parties. In my case, and given final report, my lord. And submitted charge sheet in the other case, my lord, against me. And the next, my lord, the affair was lost under section 341, 291, 506, and 354D. In the 161 statement, the informant himself did not speak about 354D, my lord. Therefore, the submission of charge sheet 294, 506 is there.
Yes, sir.
And further, my lord, he in the FIR he has stated the accused has threatened my tenants, but the tenant has been examined. In this case, my lord, I have annexed the certified copy of the FIR 161 statement. The tenant did not speak anything. This is my Dharana Naik, my lord. I am next. Dharana Naik. He has not stated anything. Nor I have about threatening, nothing is there. So the whatever affair was there, my lord, in 161 statement, he had not supported the own affair, her affair, my lord. He has stated something else.
Charge sheet and all has not been submitted yet.
Yes, my lord. Charge sheet has been submitted. Yes, my lord.
Then you can take all, please, sir. Permitting the petitioner to raise all.
This one will go directly to call for CD, my lord. Yes, that is CD call. Because in my sorry, moment, my lord. In my affair, my lord, he has not examined me, my lord.
It's all right.
Nor examined my witnesses.
All right. Charge sheet has already been filed, permitting the petitioner to raise all pleas to their property.
Adjourn this case to next week, my lord. I will file a list of documents so that it will be no data, list of data.
No, thank you. Yes.
Item number 63.
None appears dismissed.
Item 63, your lordship. On behalf of UC Misra, in this case, charge sheet has been submitted. Your lordship may kindly dispose of the matter with liberty to.
Yeah, permitting the petition. Yes.
Item 64.
64, my lord, in this application, the petitioner prays for quashing of criminal proceeding. On the ground, petitioner number 1 has already married to OP number 2 victim, my lord. And the victim and the informant do not want to proceed with this case. My lord and brother is appearing.
In this case, my lord, I am appearing as a victim and informant, my lord.
All right. Counsel for the opposite party number 2 states that he
affidavit, my lord.
Yeah, tenders an affidavits in which he states that she has married the petitioner and they're living happily together. That view of the matter taken to prayer clause and all proceedings consequent thereto. I hereby question.
Item 65.
None appears.
66.
May I please, Your Lordship? This application filed was the criminal proceeding on the basis of compromise between the parties. In this case, this Honorable has issued notice. As per noting, the advocate for the opinion 2 has also entered appearance.
But none has come, sir. Where is he? He's not there today. Okay. You see, Mr. KP Das, advocate, who was earlier appearing for opposite party number 2, is not present today. The registry will inform him telephonically to remain present at the next date.
7.
My lord, I am permitted to withdraw this.
All right. Dismiss this withdrawn.
68.
My lord, see.
Yes.
Your Lordship may kindly see the petitioner prayed for quashing of the affair. Your Lordship may kindly see the informant was not present at the time of occurrence. I have received the information through RTI. I have filed an additional affidavit. Your Lordship may kindly come to the additional affidavit, page 5.
No, where is Mr. What's his name?
Satrughna Das.
Chinchari.
PC Chinchani.
Chinchani.
I am for the private opposite party, my lord.
So
I have not received copy of the additional affidavit.
A copy of the additional affidavit be served on Mr. Chinchani, counsel for the opposite party, within 2 days. List before the roster bench on 4th July. Is there an interim order?
Yes, my lord, interim order is there.
Interim order to cut. All right.
Item number 69.
May I please, Your Lordship? My lord, the petitioner is challenging the order of cognizance dated 15 February.
Compromise affidavit. Who's appearing for opposite
My
party
lord,
number 2?
Nothing.
Ah.
My lord, I am appealing the matter has been settled, my lord, and one of the 2 petitioner, one petitioner is dead, my lord.
Okay.
And the other petitions, my lord, with the intervention of the village entities, the matter has been settled, my lord.
Well, only one petitioner here.
Yes, my lord. Before filing of the application,
Or counsel appearing for opposite party number 2 confirms that this disputes have been settled between the parties and that compromise affidavit is also on record. In that view of the matter, take the prayer clause and all proceedings consequent that we have quashed. All right.
Item number 70.
Oh, bless.
May I please, Your Lordship? Your Lordship, the petitioners here and the bank official of a nationalized bank, my lords, I will just shortcut the brief that the informant applied for a loan of extent to the 2 crores. The bank supplied the loan, sanctioned the loan. Thereafter, at 2017, what has happened? By authorization, and which is critical under Annexure 4, by authorization, they wanted to purchase a cement.
Opposite party number 3.
The informant, my lords.
No. Mr. Arvind Tripathi. Where is he?
Lords, notice has been issued.
Yeah. Mr. Arvind Tripathi, counsel for opposite party number 3, is not present today. Registry telephonically inform him to remain present at the next date. Interim order to continue. List before the roster bench on 11 July.
I am grateful, my lords.
Item 71.
May I please, Your Lordship? Here, my lord, notice has already been issued to the informant, but nobody has entered appearance.
In fact, my lord, I am appearing. This is question of FIR, Your Lordship. Questioning of FIR.
Questioning of the affair, but basic.
2 nascent stays to be challenged.
No, but
I can apparently show there has been manipulation of my signature.
Yes, I want to draw my lord's attention
and
to
the
affidavit which I have filed. The affidavit which I have filed, my lord, on page 6, my lord, may kindly see, which is at flag B, my lord. My lord, here I have quoted 2 provisions of the code, my lord, section 340 as well as section 195. I have also drawn my lord's attention in paragraph 6 that section 340 of the code makes it clear that a prosecution under this section can be initiated only by sanction of the court, under whose proceedings an offense referred to 195(1)(b) has alleged been committed. The object of this section is to ascertain whether any offense affecting administration of justice has been committed in relation to any document produced or given. Well, the allegation, if will be taken into consideration that I have manipulated the court record It is the court, as my lord 195 1B clearly stipulates. My lord McAllister was section 195 1B of the code. It's very clear. If my lord and friend will answer the same, then I have no case. And I have got fortified with 3 Supreme Court judgments which I have brought.
All right, let it go before the roster bench. We'll consider it.
The only thing is that
It's 5 to 5.
my lord, as your lordship pleases, but here the distinction is with regard to an offense against vis-a-vis me and the court proceeding. So if there is a cheating and manipulation vis-a-vis me, I can maintain a FIR.
Let that be.
On 26th June. All right.
Item 72.
Well, interim order to continue.
All right. Interim order to continue.
72.
None appears dismissed.
Item number 73.
Same order.
May your lordship, by what? Your lordship, this is a petitioner filed for the 482 quashing of FIR. FIR on the basis of compromise between the parties. Annexure 3, your lordship, kindly see page 21. Amicable complainant has filed a compromise petition. And Annexure 4 is a letter to the IAEC Chandanpur dated 19th July 2018. He has not proceeded to further proceeding. Amicable settled between the parties, your lordship.
This is item number
73.
73, your lordship.
Despite valid service of notice on opposite party number 2, he has not appeared today. The quashing is sought on the basis of an agreement.
Your lordship, agreement
Dated 18
letter
July
and Annexure
2018.
5 also.
The IIC of the concerned police station will confirm if the agreement is a genuine one and file a report in this court before the next date. Interim order to continue. List before the roster bench on 28th August.
Obliged, your lordship.
Item 74.
None appears dismissed.
75.
Same order.
Item number 76.
Same order.
77.
Same order.
Item number 78.
May I please, Your Lordship? I'm challenging the order of cognizance under Annexure 6, my lord. Offense, my brother is appearing for the opposite but on 2, my lord.
I can do, my lord. 2019, my lord.
All right.
Your lordship
Counsel for the opposite party number 2 has no objection. States on instructions that he has no objection to the prayer in the present petition.
No, my lord.
Oh, this is ST.
ST, my lord.
376 and 3 SC.
Matter has been compromised, my lord.
No,
Can't be
Case 35,
compromised.
my lord.
No, this can't be compromised. Sorry.
No, my lord.
This can't be compromised. Permitting the petitioner to raise all pleas in the appropriate stage. The petition is disposed of. All right.
Item 79.
May I please, Your Lordship, my lord. I have challenged the order of cognizance, my lord. It is a case of defamation. Section 500, 507, 294 of IPC, my lord. Allegation is that, my lord, some anonymous emails have been circulated and sent to, my lord, BSCC 2 University, my lord, and its officials with derogatory statements using unparliamentary language. My lord, here, my lord, during the investigation, it was found one of the mails, my lord, the service provider of the Geo from them, as it is ascertained the C1 SIM card, my lord, was registered in the name of the present petitioner.
Yes.
My lord, on the basis of, my lord, suspicion, my lord, he has been entangled in this case.
All right.
And my lord, the present petitioner, my lord, in the assistant professor, Department of Mechanical Engineering in that college. My lord, except that, my lord, no allegation.
No.
With the
Permitting the
lordship,
petitioner to raise all pleas at the appropriate stage. The
my lord, 500, my lord, as per section 199 of CRPC, is a bar, my lord, is filed to complaint case.
That's, you can segregate it out. No problem. Yes.
Item number 80.
I will raise the points, my lord.
Yeah, that's what we said. Permitting you to raise all pleas.
Let's item 8, I seek 2 weeks adjournment on behalf of Mr. Mohanty because his father expired.
All right. Counsel for the appellant is, I mean, petitioner is stated to be difficulty to discuss. List on 17 July. Oh, all right.